All right. Ladies and gentlemen, both the state and the defense have rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments that are intended to aid you in the understanding of the case. Each side will have equal time, but the state is entitled to divide its time between an opening argument and a rebuttal argument after the defense has given its closing. State, whenever you're ready.
Counsel, may it please report, Your Honor? Two minutes and 6 seconds is what it took to end the life of an innocent child and change the life of her family forever. 2 minutes and 6 seconds is what it took for the defendants seated before you, each and every one of them, to play a role in this case in the murder of Suni Bell and in the attempted murder of her mother and of her uncle on Hillsborough Avenue on August 22nd of 2021. 2 minutes. The defendants, for 2 minutes before that, lie in wait, arm themselves with firearms, put on masks, wave each other on to enter the vehicles before jumping in to all of the cars depicted in the video that you've seen and chasing down the victims. They're charged with first-degree murder. They're charged with conspiracy to commit murder. The court will read to you the jury instructions that are applicable to the charges, each and every charge that you need to look at the instructions for, to determine whether the state has met its burden in proving to you that each of these defendants, regardless of who pulled the trigger, have blood on their hands in the death of Suni Bell. Throughout this trial, we've seen a lot of evidence. It's our job as the state to hold the burden to put that evidence together for you. We've presented to you experts. We've presented to you the testimony of the medical examiner to establish that Suni Bell was the person killed. But we have not had an opportunity to actually introduce to you 4-year-old Suni Bell. Just starting school.
Overruled.
She was the back seat passenger while her family was attending a celebration of life. But they made a mistake. They violated the rules. According to these defendants, you can't get lost around their neighborhood. You can't drive too slowly near them. You can't stop to look for directions, and you certainly cannot be lost. Because for the less than 2 minutes that Willie Brown was parked in that field, waiting, trying to reach his cousin, the defendants prepared. They got masked up, they got armored up, and they got ready to go to war. Unfortunately, their common enemy was an innocent child and her innocent family members. Each of the defendants is charged in this case, and each of the defendants is guilty. Each played a role in the crime that was committed, in shooting repeatedly into this vehicle. You do not discharge a firearm one time at another human being with the expectation that things will be fine, with the expectation that that person would live. You do it to kill. In looking at the surveillance footage from the gas station, the utter excitement experienced by everyone running around, picking up guns to hunt down this car and shoot at it, is indicative of their plan to kill the occupants inside. The number of shots fired at this same individual car is indicative of their intent to kill. It is not the state's job, obligation, burden to jump into the minds of any defendant. It's impossible. We talk about motive to say, what is the motive? Why isn't it an element of a crime that we have to prove? Because we can't 100% ever tell anyone what is in the mind of that person when they commit this act. We heard in jury selection from a juror in the back who was working as a receptionist of some kind, and the man came in and kind of destroyed the place a bit. His intent was to destroy the place. Walked in, threw, items all over the floor, destroyed the inside of the reception area at her business. None of us will know the motive. Was he upset with an employee there? Did he have a mental health issue? That is the difference between motive and intent. We don't know what your motivating factor is in committing this crime. But you don't shoot into a vehicle this many times with the intent that anyone lives. Starting first with the passenger of vehicle number 1 that we see on these videos. This is Quandarious Hammond. He's the only occupant that you see enter the vehicle with Zvante Sampson. The photo in the center here is what we showed you from Mr. Hammond's social media. He likes to match these items or pair these items together. On either side are the same outfit that he was wearing on the night of the homicide. This is Quandarious Hammond. Quandarious Hammond is the person who walks to the white fence line and crouches down there for just under 2 minutes waiting for James Denson to come back from his lookout point across the street. Just after the victim's silver vehicle passes, he exits the frame and then re-enters crouching down in that same spot. When you watch the video of him getting up from that crouched position, what do you know? The firearm that you have in your cell phone evidence, depicted in the image on the right, photographed the day before, is in Mr. Hammond's hands. Here's Mr. Hammond. There's no point that the state will concede that there is audio to what the defendant's actions were from this video from the gas station. But what the state does assert to you is that it is plain as day what their intentions are. Mr. Hammond is pointing, Mr. Hammond is clearly communicating with the others nearby, and Mr. Hammond is clearly waiting to ambush. At least at this time, fortunately enough for the victims, they don't come back down Giddens on the other side of these defendants. They head to Hillsborough, because we heard from Willie Brown he saw the defendants pointing at him and decided not to stay there. Everyone in the videos you see walking around with guns, some masked, some not. The driver of the vehicle that Mr. Hammond gets into is Zvante Sampson. You have to watch him in the video independently. In the video that we showed to you all, which depicts each of the defendants zoomed in on them, has been admitted as an exhibit if you wish to watch it. Because there was a lot of evidence in this case, and it is difficult to ascertain when you watch this. I mean, I watched the video dozens and dozens and dozens.
Sustained.
It's difficult to ascertain who was doing what. So an exhibit that has been admitted for your consideration is that which depicts each of the defendants, follows them through the frame, so that you are also able to focus on what did this person do in the parking lot. Why has the state charged them as a co-conspirator? Why has the state charged them as a principal to all of the crimes charged? You'll see Mr. Sampson pointing, you'll see him talking with others, and you'll see him lead the charge when they exit that gas station. Here's Mr. Sampson with the gentleman in red, who the detective testified was Mr. Sampson's brother, Devin Sampson. Devin Sampson's pointing towards the direction of the vehicles that were passing behind the gas station, their targets. There goes Zvante Sampson pointing towards those same individuals, and the moment that Jaylin Bedward enters and trips. Quandarious Hammond enters his position to crouch down and hide, lying in wait, and Zvante Sampson returns to his vehicle. In the video, which follows Zvante Sampson, you'll see while he's at the video, while others are trying to track the car and locate the car, he's pointing, he is waving them on to get into the vehicle, and he takes off. How do we know that Zvante Sampson knew of the common scheme of all of the others? Because he is driving the first shooter. Because all three vehicles target the same victim, the same car. At this exact timestamp, you'll see from some further slides, the victim's vehicle is crossing the boundary of the chevron on Hillsborough Avenue. Looking now to Andrew Thompson.
Your Honor, may I get close, please?
Yes. Continue.
Andrew Thompson, who by the end of the videos you see entering the passenger seat of the Chrysler 300 with Mr. Bedward as the driver. Now, we all know that all of the defendants have admitted or identified themselves from the video surveillance from the night of the offense. They've identified themselves as drivers of the vehicles, etc. But what's interesting about Mr. Thompson is that the minute that Jaylin Bedward trips over that rebar and gets back to the vehicle, he rips his shirt off and ties it around his face like a mask. I don't know what they're saying to each other. I won't assert to you that I know what they're saying to each other, but I get the gist. How does Zvante Sampson tie into what Mr. Thompson and Mr. Hammond are doing at the bottom left of the screen? Well, Mr. Bedward and his brother go out into the field to watch the car ride by, and right in the middle of the frame, Mr. Sampson makes some kind of hand gesture to Mr. Thompson and Mr. Hammond, at which time they return to their vehicles and arm themselves with firearms. Mr. Thompson has repositioned himself behind the dumpster. Watching, waiting. Mr. Bedward, gone to the vehicle, changed from a handgun now to his AR. Mr. Thompson returns to Mr. Sampson's vehicle. We have footage that Mr. Thompson enters the passenger seat of the Chrysler 300. When we get to the timelines, you'll see there was no opportunity for anyone other than Mr. Thompson to be in the passenger seat of that Chrysler 300. Jaylin Bedward identifies himself as the driver of the Chrysler 300 that night. He's there in the frame, standing just behind on the left-hand side here, his brother, person who at least brings their attention to somebody driving on the back road. Mr. Bedward, after changing from a handgun to an assault rifle, pointing out to the others from behind the dumpster there, right in line with our timeline of the victims driving up 43rd to head on to Hillsborough. Giving directions to everyone else as to where their target is. All because at the start of this video, the victims, depicted in the top right here, drive on the road that, according to these defendants, they're not allowed to ride on. As you play back these videos, you'll see the victim's headlights just opposite the street of Giddens, which is the street that they're just nearest to, having turned down the other road to come up and park into the field. We know Jaylin Bedward has admitted to possessing this AR, and we know that there is an empty box in the trunk associated to an AR-15 that was not recovered in this investigation belonging to Mr. Bedward. I've told you that the first time he passes after he trips on the rebar, he switches out his weapon. Mr. Bedward has a handgun when he runs back to his vehicle. And when he comes out of that same vehicle after his exchange with Mr. Thompson, he now has an assault rifle. Now, James Denson, also identifying himself in the footage, does the same as Mr. Bedward and Mr. Bedward's brother, watching the vehicle. If you look very closely, you can actually see the vehicle turning right onto this roadway before it turns right again, coming back the opposite direction. Mr. Denson actually runs across the street, disappearing from view for 2 minutes before running back to join Mr. Hammond and Mr. Thompson at the cache of guns right behind the dumpster. And before they leave, in his excitement, he is sprinting to the backseat of that Chrysler 300. Everything starts out as normal until he joins all of the others. But Mr. Denson's role, at least preliminarily, is to stay across the street for an extra 2 minutes before he runs back over and gives updates. Just before the vehicles depart the gas station, Mr. Bedward enters the driver's side of his vehicle. Vehicle 1 leaves. Vehicle 2 leaving just behind them. And here comes James Denson. He doesn't want to miss out. Everyone's jumping, running to get to the cars because they don't want to be left out. Here is the exhibit that we've also admitted into evidence for you all, because I certainly understand, given the volume of evidence, how difficult it would have been to document each of the witnesses' statements regarding how far off the videos were from real time. So this is an exhibit that you will be able to have with you back in the jury room. It is a summary of the timestamps and their accuracy, fast, slow, etc. For purposes of this presentation I'm giving to you, I have adjusted the timestamps according to this summary I've provided to you to reflect exactly when we see the vehicles on the videos. Starting first with the victim's vehicle passing the chevron, which occurs at 9:03:26. The defendants are running in the top left corner to enter the vehicles to drive out after the victims. 9:03:48. Vehicle number 2 exits, 9:04. Vehicle number 3, 9:04:09. Now, the focus is vehicle number 1 and vehicle number 3. Because as you've heard testimony of, the state must have proof beyond a reasonable doubt in bringing charges. And at this time, there are not sufficient charges against the occupants of vehicle number 2. Because for us, we have evidence that vehicles number 1 and 3 discharged their firearms towards the victims. What that means, though, is you must consider the evidence of the crimes we have against these defendants. There is no law which indicates you don't have enough defendants. There were too many shooters. There was too much evidence of ballistics at the scene. You don't get away with murder because you had too many accomplices. There's no law which supports that these defendants would not be held responsible because everyone responsible was not also tried with them. Now, we know from the video surveillance that the defendants all leave the Chevron gas station with this red arrow in the center of your screen. They head up just past Power Electric Services, heading east on Hillsborough Avenue, and immediately make that U-turn. The first camera that we pick up is that Power Electric Service camera that gives us audio from both shooting vantage points. So you hear one round of shots, a break, you see vehicles number 2 and 3 passing, and you hear yet another round of shots. So I'm going to give you timestamps because when we play it all together for you out of context, it gets pretty convoluted. You don't know which videos are overlapping with which. But ultimately, from this diagram, the yellow spot is where the vehicle first stops and Willie Brown jumps out and runs north towards Mr. Coberly's residence, where we catch him on camera with all the cobwebs around it. You still hear ballistics. You still hear shots ringing out as he's running. You barely see him on the footage because he's a blip, he's running so fast, but that's the first stopping point for that vehicle. There goes the victim's vehicle, and vehicle number 1 just after it. Before vehicle numbers 2 or 3 at the Power Electric location. So we're looking at video from the location all the way to the right on your map, the red pin all the way to the right. Before vehicles number 2 or 3 even pass that camera, shots ring out from vehicle number 1. Vehicle number 2, and finally the 300 vehicle number 3. So we first see on this vantage point the victim's vehicle at 9:04:27 p.m. It has driven past the Chevron coming east and made a U-turn and is now headed west back the other direction. 1 second later, we see Zvante Sampson's vehicle with Mr. Sampson as the driver passing this camera angle. Quandarious Hammond is the passenger of this vehicle, 1 second after the victims. Timing-wise, given they've made a U-turn from the location that's also depicted of the Chevron just up the road, there's no opportunity with a 1 second gap in the manner with which they caught up to have changed a thing. The defendants exit the gas station, and as Willie Brown testified, got right behind him before the U-turn. He did not think anything of it at that time. Zvante Sampson admits to being the driver of that vehicle, and Quandarious Hammond has given a version of events, which is that he was let out. You heard a jail call between he and his girlfriend, during which he's trying to convince her, essentially, to say she picked him up. And she says she can't. She already told the police. She's in St. Pete. You see, at the end of this frame, all the way down the roadway, the brake lights coming onto Zvante Sampson's vehicle as he's catching up with the victim's vehicle. The gunshots begin at 9:04:38. In lieu of leading you with the following vehicles after this, I'm going to keep you with vehicle number 1, driven by Zvante Sampson and occupied by Quandarious Hammond, at the next view of the camera. That's your first round of shots. They go off before vehicles number 2 and 3 into the frame. And as a result of those shots at the exact same timestamp on the Lorenzo's garage video camera, you see the victim's vehicle coming to a halt. The screenshots from the Lorenzo's garage camera reveal at the same exact second that the shots start, according to the last video we saw from Power Electric, the victim's vehicle is coming to a stop in the far right lane, and the defendant's vehicle is shooting into it, consistent with the audio we hear from Power Electric. Michael Coverley's residence, before it actually depicts the victim, Willie Brown, running onto screen, also captures those shots. And at 9:04:38, you actually hear a gap in between the first round of shots and the second. And it's so hard to see, but as you take this video back with you, you can actually see Willie Brown sprinting to this door. We heard from Mr. Coverley, whose home this camera is attached to, that he ran to his house, that he said someone's trying to kill him. He's running house to house to try to get help. You heard from the law enforcement officer who made contact with him, who he said the exact same thing to. We know that the ballistics evidence from Mr. Kwong also indicates that group number 1, firearm number 1, is the only gun whose casings are between 45th, which is where Lorenzo's garage is. So a vehicle moving at any rate of speed, discharging a firearm out of the window, drops casings from 45th up to the marker of 12. The only gun with casings which are limited to the first half of the roadway. All of the other guns go beyond 43rd Street. And we know from the Deland trucking video that Zvante Sampson and Quandarious Hammond turn left onto 43rd Street. All of the other guns have a casings beyond 43rd. Gun number 1 belongs to Quandarious Hammond. Because when that vehicle turns onto 43rd Street, there's no other mechanism for shots to have been fired. In fact, the fact that the vehicle stops at Lorenzo's garage and the casings stop halfway down the roadway are indicative of the fact that Quandarious Hammond thought he was successful. The vehicle stopped. But unfortunately for Mary Bree Harrison, when she got into the driver's seat in an attempt to save her life and her child's life and stepped on the gas, the vehicle starts to move again, and the shots also start back up. When you look at the key provided with all of the shots divided by color, again, those in red are limited to vehicle number 1. All of the other 2 vehicles pass 43rd Street. We know that the defendant, Zvante Sampson, turns left onto 43rd Street because the vehicle is tracked on Deland trucking video turning left onto 43rd, driving around another vehicle in the opposite lane of traffic, turning back left on Frierson again, and turning up 44th to make it back to the Chevron gas station. At the time they finished shooting, the vehicle was left at Lorenzo's garage, and Ms. Harrison's getting ready to jump into the driver's seat and drive it away. Power Electric Services, all the way to the right of the screen, though, also captures a few seconds later vehicles 2 and 3 entering the frame. And vehicle 3, the Chrysler 300, is occupied by Jaylin Bedward, Andrew Thompson, and James Denson. Andrew Thompson is your front seat passenger in the Chrysler 300, Jaylin Bedward is your driver, and James Denson is the back seat passenger. That vehicle passes into the frame at 9:04:49 p.m. Here comes the Chrysler 300. And we have Bay City Cabinets footage, which also captures that second round of shots at 9:05:05, just across the street from those school buses. It's so very fast, but when you watch back at a slower speed, you see the victim's vehicle entering the frame. Here in the center, followed closely behind by vehicle 2, and then the Chrysler 300. So we did what we spoke about with many of our witnesses, which is slow down that video and try and watch it frame by frame. What happens when that Chrysler 300 actually passes through frame by frame? Victim, vehicle 2 on her left, and vehicle number 3, the Chrysler 300. We're looking now at the driver's side of the Chrysler 300, but even then we can see the power of that muzzle flash. Wasn't enough that the vehicle was already stopped the first time. It wasn't enough. They kept shooting at the vehicle. Looking now, 2 seconds later, at the auto upgrade, just across the street. So we've passed Bay City Cabinets. It took 2 seconds for that vehicle to discharge on this roadway and keep discharging until we intercept auto upgrade and principal auto sales. The crash location, the pole with which Miss Harrison crashed into, is right here. We know auto upgrade doesn't capture the actual crash location, only the vehicles approaching, but it does assist us because it actually captures 43rd. Then principal auto sales has 2 views, one facing northeast and one facing northwest. For auto upgrade, 2 seconds after the Bay City Cabinets shots, we see the Chrysler 300 enter the frame again. On principal auto sales, 1 second later, so just as the Chrysler 300 passes through that intersection as described for us by Detective Alverson, this is the same intersection as this, from the opposite side of the roadway. And there's the Chrysler 300, continuing to shoot into the vehicle, the victim's vehicle that is ready to crash into the pole, the victim's vehicle that ultimately does. More shots. From this angle, you see even after the vehicle has crashed into the pole, there are shots coming out of Jaylin Bedward's vehicle. The vehicle in which James Denson and Andrew Thompson are also riding. The vehicle which we know James Denson doesn't have an assault rifle because he shot his own 9. The same one he pawned a month later, for whatever reason. While the vehicle's crashing into a pole, vehicle number 1 is returning to the Chevron gas station because you can't leave your bag of guns at the gas station. You have to go back and pick them up. So Zvante Sampson returns with Quandarious Hammond, Their windows are down, they're talking, they're hanging out. They arrive back. You have the videos where their vehicle's returning to the Chevron. Quandarious Hammond, his specific video, we've already seen, has him going behind the dumpster and then walking back to the houses in the back to meet back up with Mr. Sampson. Impossible that they would have shot rounds other than the red grouping number 1 because they turned left onto 43rd. We see those screen grabs from after 43rd where the vehicle crashes into the pole, which is again the black either rectangle or the rectangle with a triangle on top, whatever it is, but the circular area never changes across any of these scene diagrams. The only vehicles that passed the victim crashed there in that vehicle. The only vehicles that passed 43rd are those occupied in Vehicle 2 and Jaylin Bedward's vehicle with Mr. Denson and Mr. Thompson inside. These are the charges that you will all be asked to make a decision as to the guilt of these defendants. The state has proved that the defendants acted with a premeditated design in the killing of Suni Bell and attempted to murder Ms. Harrison and Mr. Brown when they shot into that vehicle. They're all charged in count 4 with conspiracy to commit murder. That means they all came together, combined, confederated, conspired. They all came together in some way, by word, by act, with the same goal in mind, which was shoot as many times as humanly possible into this silver infinity. The judge will instruct you, you're permitted to use your common sense. 40 shell casings collected, at least that many rounds going off into the same target vehicle. They're also charged as principals to shooting at, within, or into a vehicle. You have to determine whether they acted together to commit what was the ultimate goal, shooting into this car. And lastly, discharge of a firearm from a vehicle. Only the person that has been charged with actually pulling the trigger or pulling a trigger has counts of discharge of a firearm from a vehicle. So we'll go through those so that it makes more sense as to who is charged with what. All of the defendants are charged with first-degree premeditated murder. You say to yourself, how, when there's nothing, no evidence to support that they even knew Suni Bell or Mr. Brown or Miss Harrison, none. How are they charged with premeditated murder of someone they don't know? Unlike what we might see on Dateline or, the news stories that are really, really salacious. Your typical murder doesn't occur by sitting down at the dining room table and writing out a contract to do it. That's not what's required by premeditation. That's not what's required by the law. You don't even need to know the victim's identity. Remember, Mr. Terry spoke about what happens in a mass shooting, for example. You're in the car and make sure you have all the weapons and you're going to go into a mall. You don't know the name or identity of your victims, but you planned to do an action. You had in a forethought to commit the act that you committed. Each of the defendants, by act, by word, in that parking lot, acted in a manner consistent with them all being on the same page. Principles by act, conspiracies by act. You don't need to know what they said to know they had a common scheme or plan to commit this crime. It's not, did they plan to kill a 4-year-old child? It is, did they plan to open fire on a vehicle in the middle of the road over and over and over and over again?
Objection for argument.
Overruled.
And each of these 5 defendants achieved that goal, regardless of whether they pulled the trigger. I will give you specific examples because only Mr. Hammond, Thompson, and Denson have firearm discharge language, and actually no one is charged with shooting the bullet that actually kills Suni Bell. Because with a through-and-through wound, it's impossible to tell whose bullet did it. But it would not have been accomplished without the actions of every single person depicted here. In count 1, these are what your instructions will have. Suni Bell is deceased. That death was caused by the criminal act of the defendants, and there was a defendant or defendants, and there was a premeditated killing of Suni Bell. So we saw an instruction from Ms. Bradley about multiple defendants and considering them independently. You do need to look to each defendant to say what is the evidence against this person. But you have the benefit of having a principal instruction that you carry with you through all of your counts, right? So this is a charge, premeditated murder. Principal to a crime is an instruction that you are given based on the facts that you look to say, if this person didn't pull a trigger, did this person aid, assist in this goal being accomplished? You'll have instructions on premeditation, and you'll have to consider what was the conscious intent of the defendants as they gathered, as they prepared in that parking lot. The court will give you a significant amount of instructions. You will also have a paper copy of those to refer back to because there's a lot of legal language included therein. But this principal instruction, did the defendant intend for the crime to occur? Did the defendant do some act, say something that intended to help the others? Encourage them, aid them in committing this crime? They don't need to know, in being a principal to a murder with a firearm, whether any of their other defendants were armed. In this case, they're all in the parking lot with several individuals running around with assault rifles and handguns. I do not assert to you that they didn't know that, but that's not even what's required. Was the common goal to go after these victims, after this vehicle, that of which the defendants had before they started shooting? You'll have specific instructions as it relates to principal to murder as well. So principal is just the instruction you carry with you through the charges, and there are specifics as to the murder itself. This is what the verdict form that you will receive from the court will look like as to each one of the defendants. So you will have a section which indicates count 1, murder in the first degree. And as to each of the defendants, you will have to make a finding. We've charged 3 total defendants with the possession of a firearm during the commission of this crime and the discharge of a firearm during the commission of this crime. No one is charged with shooting the bullet that actually killed Suni Bell, causing her death, because it was a through-and-through wound. So your findings must be, or are limited to, did Quandarious Hammond, did Anthony Thompson, and did James Denson, under these instructions, actually carry, display, use, threaten, or attempt to use a firearm? It seems duplicative, but did he actually possess a firearm? And during the commission of this offense, did he discharge his firearm? When we talk specifically as to whether the defendants have this firearm discharge language, you will see this type of wording underneath, for example, count 1 as to Quandarious Hammond, the passenger of the vehicle number 1 driven by Zvante Sampson. Did he have a firearm? Did he discharge the firearm? When it relates to the remaining defendants not charged with actual possession of a firearm during the commission of the offense. So Zvante Sampson, the driver of vehicle number 1, he doesn't have those special findings underneath his counts because he hasn't been charged by information with possessing a firearm during the commission of the murder. He's charged as a principal, as an aider to ensuring it happened, as the driver during the course of the murder, as encouraging the other defendants, telling them before they jump into the vehicles and chase after the victim's car that's just passed by the Chevron. He doesn't have special findings, but he has the same result. He's guilty of murder just as are his co-defendants. We talked about motive versus intent. Motive is not what needs to be established. There are counts for which the intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Somebody shot me.
Take him.
Somebody shot me. Somebody shot me. It's a good thing. Oh, take this thing down. Somebody shot. I feel sorry for that little girl. Somebody shot her. It's the truth. Y'all can't be quiet.
All right, ladies and gentlemen, the court's going to take about a 10-minute recess while we take care of some obvious issues. We'll be back when we can.
All rise for the jurors.
Once again, no issues with the court instructions, I take it. Very good. Is this, you may begin. Or, excuse me, you pick up where you left off.
Thank you, Your Honor. Welcome back. I hope you enjoyed your lunch. Very, very briefly, I want to go over this process itself. When you all came for jury selection, we didn't talk a lot about the facts, if at all, of the case. Just told you what the charges were. We didn't go into specifics. We didn't dig into anything, or at least tell you what you were going to see. When you came and you were selected and listened to opening statements on the case, you got essentially a preview or an overview of what we expected the evidence would show to you. But at that point, you come and you see it, and you're not familiar with the facts. You haven't lived with the case up to that point. So then we put on evidence, which is bring in witnesses that legally we are required to bring in to testify, because testimony is considered evidence, or to introduce physical items of evidence, etc. And during that process, it can feel probably overwhelming in that we are just putting exhibits into evidence and maybe they don't come together to make sense. These closing arguments are our opportunity to tell everyone what the state's case and what we've established by introducing all of that evidence to you is. It's our first opportunity to put up the actual evidence, although it's come in droves through different witnesses and, different crime scene techs or different detectives and things like that. And it may not make sense because it doesn't always come in the chronological order in which it happened or in which it was collected. So this is the first time we're putting everything together for you. That means it's the first time we're actually presenting the videos to you to establish that vehicle 1 is 1 second behind the victim's vehicle before those gunshots ring out. It's the first time that we're showing you the videos back to back, which establish before vehicles 2 or 3 even get there. Vehicle 1 with Zvante Sampson and Quandarious Hammond has already opened fire on the victims. It's the first time for us to put that to you. It is a lot of evidence and can be overwhelming to see and experience all of that. But as we go through these jury instructions, it's important for each of you to note Florida law allows for a self-defense instruction if appropriate. That means, by law, if there's a scintilla of evidence to support such, that would be provided to you in the packet of jury instructions that we're going to read here in a bit that are very, very long, and it's a lot of legalese, but it's essentially your definitions, what we were going over before we took a break. You will not receive a self-defense instruction in this case for your consideration. Self-defense is not an issue that has been presented to you, and self-defense is not supported by the evidence of this case. There is a lot of evidence that has been provided to you, but self-defense has not become an issue because there is no evidence to support you all receiving that instruction. What there is evidence of is these defendants hunting down the victims and opening fire onto their vehicle. It is on video. It happens seconds apart. It happens over and over again. First with vehicle number 1, and again with vehicles number 2 and 3 after they realize that vehicle isn't stopped for good in front of Lorenzo's garage. That vehicle starts to move again. And it's at that exact moment that absolutely captured on video is vehicle number 3 firing into the vehicle now occupied only by Mary Harrison and Suni Bell before it crashes into that pole. There is no evidence that anything else other than that occurred. And we are in a position where we are able to provide to you video surveillance evidence. That's not always the case. So you all will have that video evidence, you all will have the events which have occurred, and you all will be able to see for yourselves through the evidence when you go back. Second by second is accounted for the victims and for the defendants. In fact, you have videos that overlap with each other to ensure you have captured what happens between the defendants and the victims. And the facts are the facts. The victims do not know these people. And the defendants made a choice to excitedly jump into their vehicles armed and gun them down. So the court will give you jury instructions here after the close of all of the closing statements. So where we left off was talking about the principal instruction because there is no requirement that we establish who's shot a gun and struck Suni Bell, killing her. But this principles to a crime instruction is the instruction that you bring with you. It's the one thing that you take when you look at every single count that you have to consider in this case against the defendants. So when you look at first-degree murder, you say, is the defendant guilty with the elements that I see? Now, considering the principal instruction, is the defendant guilty as a principal for having intended to do the criminal act, shooting into a vehicle? Understanding the potential outcome of shooting into a vehicle, which is the death or expected death of the persons therein. So principle is an instruction that you carry with you. The reason that that's different, did they do or say something to encourage the others? You have the videos as to each defendant, waving each other on, gearing up, using the same bag of guns, jumping into the same vehicles, targeting the same victim. Did they do something to encourage or assist or advise, whether they pulled the trigger directly or drove the persons pulling the trigger? That differs from conspiracy, which we'll see here just in a few minutes. But let's go in order of the counts that you have to consider beyond what we've looked at, which was first-degree premeditated murder on Suni Bell. All of the defendants are charged as principals in the attempted murder of Mary Harrison. She's the passenger of the victim's vehicle. She's the victim's mother at the time that the defendants start following their car. Once Mr. Brown is able to escape the vehicle in front of Lorenzo's garage, she jumps over into the driver's seat. So on the Lorenzo's garage video, you see this pause. And if you're asking what's happening, the vehicle you'll see just at the edge of the video starts to move again. Well, when we pick that vehicle up on the subsequent videos, just across the street from that, it kind of takes off and jumps on the curb and runs into a pole. The attempted premeditated murder of Mrs. Harrison means that did the defendants again intend to or plan to shoot into this vehicle? Were they acting in an organized manner? Did they accomplish the goal that they sought out to do? Why Zvante Sampson and Quandarious Hammond are also charged with the attempted murder of Miss Harrison, even though they are driving off by the time that she subsequently drives away, is twofold. Number one, when they first begin shooting into that vehicle, it's occupied. Mr. Brown is driving and she's in the passenger seat with Sonny in the back. At that point, with that first round of shots, there's an attempted murder of Miss Harrison. But also consider, when you're looking at these facts in the principal instruction, without the actions of Quandarious Hammond repeatedly shooting out of the passenger seat to stop the vehicle in front of Lorenzo's garage before Willie gets out, the others aren't caught up. The reason they're stopped there before she has to jump into the driver's seat, before the second rounds of shots keep going again because now the vehicle's moving again, they're not dead inside. They have disabled it in this location. Vehicles 2 and 3 are then able to catch up to vehicle 1. There is an audible gap when you listen to the audio. First round of shots with vehicle 1 right by the victim's car. Gap. Second rounds of shots. Shots that are fired when Willie's already running down near Coverly's residence. They start the ball rolling. They are the first domino, essentially, to fall, which puts our victims in a vulnerable position of being stopped in a car, Ms. Harrison having to jump into the driver's seat and attempt to drive again. But unfortunately, as soon as that vehicle starts moving, as soon as there's a realization that it's going again, it's not stopped, it's not over, the second rounds of shots start up again. You saw the crime scene photos of their vehicle. There are dozens of shots more into the victim's vehicle. I won't ask you to be an expert as you look at those photos, but I will ask you to look at the impacts from the ballistics evidence in that car. There's no evidence of casings in that car or that there was any kind of violence or anything from anyone inside that vehicle. There's no evidence other than that these 5 people came together to attempt to kill the passenger, the driver, and did actually kill the child in the back seat. The third count that you have to consider is going to be the premeditated murder of Willie Brown. You may ask yourself, why in this instance are we looking only at Quandarious Hammond and Zvante Sampson for purposes of this charge? Why isn't this also a principle? The attempted murder of Willie Brown occurs, as we can see from the video footage, before the other 2 vehicles arrive. So while maybe they intended to catch up and also engage with Mr. Brown, he has escaped the vehicle before vehicles 2 and 3 arrive. The only persons that we would charge or could charge with his attempted murder are the individuals who directly can be linked to that shooting. Once he runs from the vehicle, there's no way for us to say beyond a reasonable doubt that the other shots were directed at Mr. Brown only. We present to you we present to you facts which can support the state's position of what the defendants are guilty of. They took fire or fired down on that vehicle alone, vehicle number 1. They started out by themselves. So the attempted murder for Willie Brown, as it relates to that vehicle before the other vehicles caught up, are only as to these 2 defendants. When you look at the verdict form, you'll just see options for these 2 defendants on this count, because by the time Willie is running away, the other 2 vehicles are catching up to Mary and Suni Bell. That's why the occupants in everyone's vehicle are responsible for what happens after Miss Harrison takes off. Looking back to count 4, again in conspiracy, everyone's charged. So when we talk principle, that's the overarching instruction that you get to take with you and you look at all of the others. Look at the elements and say, does this apply as we're reading it, and then does this apply when we add principle? Conspiracy to commit murder is its own charge. The language within the conspiracy count is different. So you'll look at, did they confederate, did they combine, did they work together essentially in committing these acts? Now the conspiracy itself is not the physical act of what you're doing, right? It is the portion of talking about, acting in a manner consistent with, it is conspiring to commit that crime. So when you're looking at this count of count 4, conspiracy to commit murder, you actually are looking at, did they conspire to commit the driver of that vehicle? Did they conspire to commit murder of everyone inside the car? Was it just as to Mr. Brown? Was it just as to Ms. Harrison? Was it to everyone? So you'll have an and/or option when you look at that, right? You ask yourself, they don't know each other. So is there a conspiracy to commit murder against whomever the person is that's driving the vehicle? But for this, you are able to consider each of the victims. Was there a conspiracy to commit murder on an occupant of that vehicle? When we talk about conspiracy, the court's going to give you the same instructions that you'll see here. So the language is a little bit different for conspiracy because it's an actual count. Did they conspire or agree or combine amongst themselves or other diverse persons? That's what we were talking about just a little while ago when I'm asking that you consider the evidence against the defendants here before you. It's not necessary that we too present every other person from the gas station, for example, but it could be amongst themselves. It could be that two of them have more knowledge about what's going to happen, but that a third has agreed. It could be any combination of the defendants, but did overall some or all of the defendants agree to what would occur? That's why when you're saying let's look individually at each of the defendants, you say, was this an agreement between the two? Was this an act that was committed by a combined group of individuals? When you're looking at each of the defendants, you have to say, did they play a role in this conspiracy? And I assert to you that they each played a role, particularly when you look at the video directed specifically as it relates to each defendant. Looking at shooting at, within, or into a vehicle, this is a count for which we're asking you to bring the principal instruction along with you. We're not asserting to you specifically that all of the defendants discharged firearms from their vehicle, but whether they acted together to accomplish the shooting at, within, or into a vehicle as a group. These are the instructions that you'll be provided, again, as it relates to each of the defendants in determining whether they acted at, shooting at, or within, or into a vehicle, or whether they acted as a principal to the same charge. The court, again, will read all of these to you, so I don't want to spend too much time going through or reading them to you, but essentially we're asking that you apply the principle specifically as it relates to the shooting at, or within, or into a vehicle charge as well. And lastly, count 6. This charge is unique in that it only is applicable to those who did discharge a firearm. So we're not asking you to bring in or take with you the principal instruction as it relates to Mr. Hammond, Mr. Thompson, and Mr. Denson, the three that have that firearms discharge language on their verdict form, because each of them have some piece of evidence supporting the fact that they did actually discharge a firearm from those moving vehicles as they attempted to gun down the victims in this case. Very briefly, I will go through these lesser included offenses. You will receive in your packet what is essentially the primary charge. So take first-degree murder, for example. You will receive instructions on what are called lesser included offenses. So when the court's instructing you on these are the instructions, these are the definitions for the charges that you will receive, you'll be sent back and start your deliberations. You could be in this stronghold with someone else who absolutely agrees that we have met all of the elements as it relates to second-degree murder in lieu of premeditated first-degree murder. So say you're split in that. The court's instruction to you will be that you must return a verdict for the highest count that you all agree on. So if you all agree as it relates to second-degree murder, even if several of you indicate that you believe it is in fact first-degree murder, there was a sufficient time for that premeditation, then it has to be a returned verdict for the highest count that you all agree to. It has to be a unanimous verdict as to the count that you believe was satisfied. Specifically about second-degree murder, you will be instructed that the victim has died. You will be instructed that that death was caused by the criminal act of a defendant or these defendants acting together, and that there was an unlawful killing of the victim by an act that was imminently dangerous to another person. So was there an imminently dangerous act? There is an instruction for imminently dangerous as well. I have provided it very, very concisely here, but you will also be provided this instruction from the court. When you actually read through this instruction, the part that can get confusing is prong 2. Is this done from ill will, hatred, spite, or an evil intent? The act of shooting a gun at another person is inherently done with ill will, spite, or an evil intent. That is what I will assert to you about this second-degree murder definition and instruction included in imminently dangerous to another person. You also, as to the lesser included offenses, will have manslaughter and attempted manslaughter. What happens with these lesser included offenses is, so you say first-degree murder, second-degree murder, has that been met, or alternatively manslaughter, has that been met? And for manslaughter, that is a lesser included offense as it relates to first and second-degree murder. And the only elements therein are that the state has established that the victim is deceased, and that the defendants intentionally committed an act that caused that. It is somewhat different in the attempted manslaughter by act because the person is not deceased. So did the defendants intentionally commit an overt act that would have resulted in the death of the person that they committed the act upon, but they were not successful? This is Suni Bell. This victim was hunted down by the defendants because they wanted to accomplish one goal, and that goal was to kill the occupants of the silver Infiniti they saw driving behind the jet. It was driving too slow. It was parked for 1 minute too long in the field. Whatever their motivation, they targeted this vehicle, this child. this family.
Overruled.
The defendants in the video treat the Chevron gas station, like some kind of a bunker in a war zone. They hunker down, they take cover, they get armed, they put masks on. And the only enemy that they encountered was Suni Bell and her family. There's no excuse for what happened. The defendants acted together with a joint goal, and they've accomplished that goal. At least one person inside of that vehicle was killed, and the other two victims of that attempted murder will never be the same. The evidence supports a finding of guilty as charged as it relates to all of the defendants seated before you. Because you don't need to be the sole person to pull a trigger for this death to be on your hands. Thank you.
Defense?
May I please report, counsel, ladies and gentlemen.
Do you need them?
Good afternoon, ladies and gentlemen. I'd like to take a moment to thank you all on behalf of Zvante Sampson for your patience and your attentiveness over the course of this several-day trial. I'd also like to apologize on his behalf as well to you. This, to put it mildly, has been a very emotional process for everyone, and it has taken its toll on Mr. Sampson as well. You know, all of us have our commitments, and all of us have our jobs and our families and our personal obligations, our work. And as we sit here for these days listening to this testimony, the evidence, the admitted documents, the videos, I think that we all understand how important this whole process is. It goes without saying that I strongly disagree with the state's assertion and their view of what's seen in these videos, which are critical pieces of evidence for you to digest. After however many times they're reviewed and what they're alleged to show. It's pure speculation. I urge you to look very closely at all of these videos. They all bring something to the table, but I would suggest that you focus certainly on the Chevron videos, the East Tampa gun and pawn video, which shows the parking lot of the Chevron, the Lorenzo's garage video, specifically as it shows the interaction with Zvante Sampson's car and Willie Brown's vehicle. Because I believe that the evidence has shown you that it contains a great deal of pure speculation. I'd ask you to pay attention to it in its entirety, and certainly you have the option, as I suspect you will, to view this video in slow motion, to view it regarding Mr. Sampson and Mr. Sampson's actions, which I think are important. But when you start talking about what someone thought, what someone said, what someone did, look at it in real time too. Because as the state has indicated to you, and I don't have the numbers, and presumably someone has written it down, this happened in a very, very short period of chaotic time. You can and you should have sympathy. So sympathy is an emotion. Sympathy is sometimes something that you can't just work around. But verdicts in this case must be based on the law, not based on any sympathy for victims under the law, Suni Bell, Willie Brown, Mary Harrison, or based on any anger that you may have toward any one of these defendants, in particular in my circumstance, Zvante Sampson, over the horrible outcome that happened here, or even his outburst in such an emotional state this morning. I told you that much of the week during our jury selection that you would hear the state and many of its witnesses say they did this, they said that, they did this. I asked you and you promised me to separate these defendants and the evidence set forth as it relates to each of them. This would include a determination as to whether or not they are principals, and whether any of them, in particular Mr. Sampson, conspired so that a particular crime would be committed. The judge is going to instruct you on conspiracy, and Ms. Ismer talked to you a bit about that, and I just want to make sure we're all understanding criminal conspiracy. Because in order to find someone to be in a conspiratorial capacity, there has to be two elements. Remember how we talk about elements in jury selection. We talk about some crimes and some theories have two, some have three, some have four. Whatever the case may be, the elements is that the intent of Zvante Sampson was that the offense of murder in the first degree be committed. In order to do that, Mr. Sampson had to agree, conspire, combined and with a confederation among themselves to cause the murder in first degree to be committed. Understand that it's not necessary that this be expressed in a particular word or particular set of words, and those words don't have to pass between conspirators. Be mindful, and we're going to talk about principles a little bit later because it's another very, very important theory that we've been discussing throughout. Be mindful of what each lawyer has elicited during the course of this trial from the witnesses, not just myself, and as well in their arguments. Be mindful of the evidence that applies to each of them individually, and whether it shows guilt beyond to the exclusion of a reasonable doubt. Be mindful of the proof, the type of proof, what is the quality of the evidence provided to you by the state for your review. Your deliberation is multifaceted. We talked about that in jury selection. It has to be segmented and it has to be specific as to Zvante Sampson and what he did and how the facts apply to him. The judge is going to instruct you that when you have multiple counts in an indictment and multiple defendants, a separate crime is charged for each defendant in each count of that indictment. And the evidence applicable to him must be considered separately. A finding of guilt or not guilty as to one or some of the defendants must not affect your verdict as to other defendants or other crimes charged. Let's talk for a minute about direct and circumstantial evidence. Direct evidence is evidence that tends to prove a fact directly that is in question in a case without the necessity of reliance on the inference of proof from other facts. Circumstantial evidence, on the other hand, is evidence that first, in and of itself, has to be relevant, and second of all, it has to be of a quality that leads to an inference that an event occurred or didn't occur. The quality of the evidence is important in circumstantial evidence as well. And that circumstantial evidence, in and of itself, needs to be proved beyond a reasonable doubt. Things that lead you to other things are dangerous, and they need to be looked at very, very closely. The state is asking you to rely on circumstantial evidence in a number of ways. Certainly, as we look at the underpinning of this case, and we will talk about it a little bit later, there is the principles theory. And I'm not suggesting that you throw it in the garbage can. I'm suggesting that you look at it very closely as to its application as it relates to each and every one of these crimes. Lead number one, they're asking you to make a determination that Zvante Sampson intended that a killing take place. That Zvante Sampson conspired and had an agreement with other people to do so without any evidence as to what was said at the Chevron during the time that he was hanging out there for those hours, while he was in the parking lot, or while he was in a vehicle with Quandarious Hammond. Leap number two is that the state is again asking you to infer that Zvante Sampson intended the killing of Suni Bell or the attempted killing of Willie Brown and Mary Harrison to occur. And that he did so by intentionally doing some act that incited, caused, encouraged, assisted, or advised someone else to commit the crimes he's charged with. Having said that, I want to talk to you a little bit about the evidence that we heard during the course of the past several days. We weren't there, ladies and gentlemen. We must search for cooperation in order to render a fair and impartial verdict. We heard from Willie Brown. Willie Brown told you that he didn't intend to go to the memorial service at DeSoto Park that day, and he got there late. He talked about the fact that when he got there, he parked in his car a little bit away from what was going on, and he saw Mary Harrison. Mary Harrison is someone that he was going through with it at the time, along with some other family members that appeared to be having some issues. After smoking some marijuana, they set off down East Hillsborough Avenue. Something just doesn't seem right as it relates to his testimony, ladies and gentlemen. He alleged that he didn't know anything about going to the gravesite for a balloon release. Mary Harrison told you that that was the intent. He never had any substantiated conversations with his cousin, Charles Dozier, Squeak, or Corey Brown about this salon after party. But when prompted, what he did tell us is that he buys marijuana from Corey Brown. There's no evidence of any other family members going to Corey Brown's salon or shop. And I'd ask you to consider Willie Brown's real connection to this trip and what he was trying to accomplish. What Willie Brown does say, which is very important as you consider the evidence in this case, is he said that Suni Bell was screaming when he got out of the car after the first set of gunshots are discharged. He told you that the shooting stopped momentarily and that the car continued to drive forward as he got out. It's also important to note that there was only one set of shots prior to him running away, and it was those initial shots that got him out of the car. At this juncture, I ask you to look at Willie Brown a little closer. I'd ask you to look at the object that appears to be in Willie Brown's hand in Defense Exhibit number 1, inside that circle and with the arrow. Take it back, look at it closely, consider it in your deliberations as to what Willie Brown may be doing. He told you that he didn't carry a gun. He told you that he didn't discharge a gun. But to corroborate this object, I urge you to take notes and go look at the 45th Street Coverly video, which is State's Exhibit number 13, and watch it at 21:05:46, and you'll see this same object in Willie Brown's hands as he is crossing the street, crossing the driveway into the roadway. Please look at it. Detective Saleha testified that he didn't see a muzzle flash from Willie Brown's car, but that would have been very difficult to do based on where the camera in Lorenzo's garage was positioned, because it was on the other side of the driver's compartment of that vehicle. It was on the passenger side. Review the Lorenzo's garage video as many times as you feel it necessary. Willie Brown told you that he ran down 45th Street and he continued to hear gunshots and believed that someone was chasing him and shooting. He ultimately located Michael Coberly to contact 911. Ladies and gentlemen, recall that Zvante Sampson was arrested on September 30th, 2021, and Detective Saleha testified that he took Mr. Sampson's statement. After being apprised of his arrest for premeditated first-degree murder and conspiracy to commit first-degree murder, he told you that Zvante Sampson, after originally requesting a lawyer, decided to speak with him. There's no question that Zvante Sampson lied about making the turn on Hillsborough Avenue, the U-turn, following Mr. Brown, Willie Brown's car, and being present when the shooting took place. It's important that he lied, and it's not lost on me in a respect. When considering someone fearing for a wrongful implication, not wanting to put themselves in a place that would have been dangerous for them to be, because Zvante Sampson was not truthful in that respect, doesn't make him guilty of first-degree premeditated murder, doesn't make him guilty of attempted premeditated first-degree murder, and doesn't make him guilty of conspiracy to commit first-degree murder. It might make him the kind of person that you yourself don't want to be. And although it's not a justification, it certainly can be an explanation. Going back to the testimony of witnesses, you also heard from Mary Harrison last week. Her emotional state was certainly understandable and apparent. She told you that she recalled the events of August 22nd, 2021, and was supposed to be going to the gravesite for a balloon release. She never got there. She testified that Willie Brown took her to a field that you saw in States 41, which is adjacent to the Chevron, and down Giddens in this area right here. During that time, he turned his engine off, he told you, and his lights, and allegedly made unsuccessful phone calls to Squeak, who was Charles Dozier. And again, I point out that the evidence didn't provide you anything to substantiate any party at Corey Brown's salon ever existed. She testified similar to Willie Brown in one important way. Recall that Mary Harrison told you, and she clearly, in no uncertain terms, stated that after the first set of shots, when Willie Brown got out of the car, the shot stopped and it gave her a chance to get away. She told you that in moving from the passenger seat to the driver's seat and starting to drive, she heard Sonny saying, "Mommy, Mommy." She was standing in the back seat. She told you that it was only before she hit that pole that at one point in time she didn't hear Sonny anymore. Why that's critically important to you is that the evidence does not indicate that Suni Bell was killed by those first set of shots. This is apparent for a number of reasons, including what both Willie Brown and Mary Harrison testified to, about Sonny being alive at that time. I'd like you to take the time to look at States Exhibit 2A1 and 22A3. First, 2A1. This exhibit would indicate to you a certain set of gunshots or projectile strikes that Willie Brown's vehicle absorbed. (22A3) would give you another look at others. Look at their formations. Decide amongst yourself as you review them what position Willie Brown's car was in when he took these shots, when he took these projectile strikes. In looking at states 2A 26 to 31, they give you some perspective about the strikes that the back seat and the window were impacted by. You'll have all these pictures when you go back to the room to deliberate. And I'd ask you to consider them when you decide what happened and how Suni Bell was killed. I'd also draw your attention to State's Exhibit 2A4, which is the other side of the car. And look at the consistency in the exit of that projectile out of the window on the passenger's back seat side, as well as the exit out of the lower door panel of that vehicle. The evidence will show you, as you look at State's Exhibit 16, which is the Lorenzo's garage video, that Zvante Sampson's car was ahead of Willie Brown's car when Quandarious Hammond fired those shots. Review that video to determine the distance between those two vehicles at such time as you see the muzzle flashes and you see the cars in relationship to each other. And you look at the bullet entry strikes in the back seat, the back car door, the window, and then on the driver's side. Some of those strikes appear to be directly into the back portion of that car. Others appear to be at an angle similar to the distance between vehicle number 1 and Willie Brown's vehicle. Further evidence to corroborate that Suni Bell was not killed by the first set of shots would be the location of the 9mm casings located within the first 300 feet of North 45th Street, which is where the gunfire began. This evidence was provided by analyst Kwong, if you remember, and the diagram he provided you indicated that there was 879 feet between 45th Street and where Mr. Brown's vehicle came to rest beyond 43rd. And the concentration of the projectiles attributed to the passenger side window of Mr. Sampson's car are there for your review, 1 through 12. And it's not 1 through 12, it's 1, 4, 5, 6, 7, 8, 9, 12, 52, which is 9 discharges. While discussing analyst Kwong's testimony, recall that he indicated that there were at least 5 different firearms discharged along the stretch of roadway on 45th Street. From 45th Street past 43rd Street, where Mr. Brown's vehicle came to rest after hitting that pole. And recall that Zvante Sampson did not carry and did not discharge a firearm. The number of weapons even exceeds the occupants of vehicles 1 and 3. Analyst Kwong also told you 2 other pieces of information, very important. First, he identified casings found on the back end of that particular roadway. To a 9mm Taurus handgun that was associated with James Denson. Secondly, he testified that there was a second set of casings identified to another Taurus 9mm handgun that was seized as a result of a separate and distinct investigation. We'll talk about that a little more later. We also heard from Michael Coberly, who came in contact with Willie Brown outside of his residence on 45th. He indicated to you that he heard gunshots, which is what drew his attention outside that night. Additionally, he provided law enforcement with his video, which you have in evidence, and I would request that you review, that captures the sound of distant gunshots that we know were still taking place on Hillsborough Avenue. And it also showed Willie Brown running through the neighborhood at different places and at different times. I ask you to review that video again as you see for a second time the object in Willie Brown's hand. What Mr. Coberly also tells you is that there's a large warehouse business that fronts Hillsborough Avenue, States 41. Shows that to you here in this area here. He talks about all of the overbrush, all of the overgrowth, all of the trees that exist going down 45th Street. And as you look at that video, you can see it as well, even though it's at night. But that's what he told you, and it's important for your consideration in that Officer Barretto testified last week, and he indicated that he responded to the scene at 45th, and part of his responsibility was to search. And what he did search was simply one small area, the backyard of the neighbor of Mr. Coberly, which was Mr. Church. And he never searched any of the areas associated with Mr. Brown's travel, whether it be before, during, or at the end of his trek down 45th Street. No search of any other property, no search of any other yards, no search of the warehouse, no search of the roof, no search of the backside of the fence line where the warehouse was. And that was especially curious when Officer Barretto indicated that part of the investigation was a determination of anything that they might find associated with Willie Brown. He said that. He testified to that. But he said it, they just didn't do it. Because there was no firearm found does not mean there's no firearm. Detective Saleha also testified last week. And you'll recall that Detective Saleha was the lead detective who conducted the majority of the interviews in this case. He collected a lot of videos, he analyzed them, and he was, as they're called, the lead. Detective Saleha at one point identified individuals to the best of his ability at the Chevron parking lot by way of the East Tampa gun and pawn video, which I believe is in evidence for you in a couple of different ways. Focus on individuals, in slow motion, and in real time. This is a real case, and real time is important. What Detective Saleha cannot do for you, and what I would suggest that the evidence shows that this video absolutely cannot do for you, is tell you what Zvante Sampson was saying and what Zvante Sampson was doing, and as importantly, what direction he was standing and where he can be seen at certain times. It's not good enough. You can't see it. You can't make determinations and leap to circumstantial evidence inferences by looking at that video. You saw it, but you're going to have an opportunity to review it. But there's danger in doing that, and we're going to get to that. He testified regarding the cars leaving the parking lot, and he told you for the first time there were 3 vehicles involved. First time you heard that. And what he told you was that he believed that the second vehicle was being occupied by Maxwell Bedward, Kimwani Bedward, Devin Sampson, and he believed Cedric Brown. Where was the investigation into these individuals? Where was the investigation into that vehicle? I know he said, well, we can't make the case, so we're going to move on. He told you that individual vehicle number 2 discharged rounds at Willie Brown's car. And note there are a number of casing groupings, if you recall from Analyst Kwong's exhibit, that would certainly be attributable to vehicle 2 and what damage was done and what injuries they might have caused. What Detective Salea was able to determine is that in addition to the Taurus 9 that we talked about earlier, there was a second Taurus 9 that had fingerprints of a Raheem Bryant on it. When Detective Salea talked to you about Raheem Bryant, and he was asked to make some attempt to identify Raheem Bryant, he told you, yeah, I looked at the video, I didn't see Raheem Bryant. And his description of Raheem Bryant, as he had his files with him, was that he was a black male. That's not an identification. There's no download of Raheem Bryant's phone to see if there's any relevant evidence, which there oftentimes is on telephones in 2025. He actually just ignored Raheem Bryant as a suspect to begin with. The forgotten vehicle 2 in this case, the vehicle that rounds were discharged from, per Detective Salea's testimony, the vehicle where he indicates there was muzzle flash from, the vehicle that left grouping of casings strewn on Hillsborough Avenue during the course of Willie Brown's travel. And how do we know this? Because based on the occupants in cars and the occupants in groupings of casings, the numbers don't work. Detective Salea then went on through video footage with you during his testimony. During the course of your deliberations, again, please look at Exhibit 16, which is Lorenzo's garage. He tells you that the evidence indicates that a gun was discharged and there were muzzle flashes from the passenger side of Zvante Sampson's car between 21:04:37 and 21:04:38. That's 2 seconds, ladies and gentlemen. 2 seconds. Seconds later, within 10 seconds, Zvante Sampson's car takes a left on 43rd Street. And that happens even before any other vehicle is in camera view, and certainly before the second series of shots takes place. It also indicates to you in another way that the rounds discharged from Quandarious Hammond's from Zvante Sampson's vehicle did not kill Suni Bell. And we'll talk about principles a little later. I would also point out for you another part of Detective Salea's testimony was communications, or what we call CDRs, cell detail or call detail records. He testified that there was communication between Zvante Sampson on the day of August 22nd, after the shooting, in relation to him attempting to contact his brother, Devin Sampson, and in the days after the shooting as it relates to some of the other co-defendants, namely Jaylin Bedward. After the instantaneous abbreviated minutes within which this chaos occurred, I think the evidence would indicate why wouldn't it make sense that these people were communicating based on what occurred. There's no record of text messages. There's no record of voicemails. There's no way for you to determine in any way, shape, or form the content of those communications. And that's why you shouldn't be coaxed down the circumstantial road in this particular regard as it relates to that inference, amongst other inferences that you are asked to string together to formulate circumstantial evidence as a means to convict Zvante Sampson. As you deliberate, don't get me wrong with regard to these videos. I'm not pointing out these videos in and of themselves for you to focus solely and completely on them, because each one of the videos plays a certain part in this horrible circumstance, but they may not all have to do with Zvante Sampson. But we'll talk about principles later. When you focus on Zvante Sampson in these videos, I think the evidence indicates that he's not acting in any way, shape, or form as a principal to anybody else, his thoughts and actions. And he's certainly not operating in any conspiratorial capacity. As Ms. Ismer showed you, and you will have those instructions to rely upon, because you take the facts in a case like this and you apply them to the law. And in this particular case, the law is the instructions that are provided to you by Judge Fuson. Ask yourself as you look at these videos, what in that video at East Tampa Gun and Pawn and the parking lot, which is the impetus for all of this, tells you without attaching reasonable doubt that Zvante Sampson got in that car with the intent to kill someone. What in that video tells you that he told someone to follow him, or he knew that anyone had a gun. You can take a segment and you can look at a particular person in this video and you can say, okay, yeah, there, he has a gun. But what you have to do in order to bring that to where you have to get to, you have to look at Zvante Sampson. That's why the instructions, and that's why the law says that when you have multiple defendants and you have multiple counts, you cannot just operate in a vacuum. What in that video shows you that he did some act or said something that was intended to, and that did incite, cause, encourage, or assist, or advise anyone to commit a murder? I would suggest to you that that video doesn't give you that answer. And I think that's the answer you would get if you look at this with clarity, if you look at that video 100 times. What in that video proves to you without reasonable doubt that Zvante Sampson intended the killing of Suni Bell or the attempted murder of Willie Brown or Mary Harrison? The one thing I ask you to lose sight of, and I've stayed on this video thing for a long time because it's prevalent evidence in this case, and I would hope that it dominates your deliberations, quite frankly. Because I don't want you to lose sight when you review these videos in real time and in slow motion, frame by frame, if you choose to do so. Looking at these videos in anything but real time absolutely distorts what Zvante Sampson may have been aware of and what in these circumstances is extremely unreliable. You know, you get the benefit of watching these videos, especially Chevron and East Tampa Gun and Pawn. I say peacefully. I mean that just as an art, in your deliberation room, quietly, if you choose, by yourself, with others, as a group, in slow motion, maybe, frame by frame, if you choose. Things can be pointed out at certain points in time when you look at something in a vacuum or in a silhouette. And ladies and gentlemen, that's not how Zvante Sampson was able to view it, to react to it, to handle it, to be exposed to it. Those videos are not what happens in real time, in the span of 2 minutes. When you look at it in real time and you see what's occurring, make a determination as to what Zvante Sampson is capable of being a part of during that time frame. That's what I challenge you to do, and that's what you should do based on the law in order to find somebody guilty of any of these charges, inclusive, and especially with regard to the use of principles, which we're going to talk about. Finally, ladies and gentlemen, on Friday, you heard from Dr. Milan Webb, the Associate Medical Examiner of Hillsborough County. He testified to Suni Bell's wounds, the wound that entered the chest and exited the back, the wound that was fatal because it damaged multiple vital organs. Dr. Webb did tell us, as Detective Saleha told us, that he could not tell what type of projectile killed Suni Bell, in that there were, as you know, 2 calibers of weapons in this particular case, 5.56 rifle rounds and 9mm rounds. Detective Saleha, just joining this thought together, was candid when he indicated to you that he could not tell you what projectile, from what gun, from what car, from what person killed Suni Bell. And we'll talk about principles a little later. Dr. Webb also testified that the injury would be immediately fatal and that Suni Bell had no function after the injury based on his autopsy and based on the review of the emergency personnel records. Again, based on Willie Brown and Mary Harrison's testimony, based on Mary's interaction with Suni during the course of their both being in that car after she took the driver's seat, after that first round of shots, and when she was attempting to get away, tells you that the projectile from Zvante Sampson's vehicle did not kill Suni Bell. The physical evidence supports that as well. I understand, as we've probably been leading up to, that the state would suggest that this argument should fall on deaf ears simply because if Zvante Sampson was a principal, it doesn't matter. Well, I believe that the evidence shows you that he was not a principal, and it does matter. Ladies and gentlemen, those are the facts that I believe the evidence showed during the course of trial over the last several days. Although I believe that the evidence has shown you that Zvante Sampson is not guilty, in considering the totality of the evidence, you should consider the possibility that, as Ms. Isber said, although the evidence may not convince you that he committed the crimes for which he is charged in the indictment and the counts that he is in charge, that he's been charged with in that indictment, which is in this case first-degree premeditated murder, which you will have an instruction on, and you'll be able to review, as you will, the rest of the charges and the elements that are required for the state to meet in order for you to find someone guilty, in particular Mr. Sampson, of that particular crime, and every other crime that's alleged, and every other element that goes with it. You can consider other acts that are called lesser included crimes. The law dictates that if you find that the main accusation has not been met, you'll need to decide, and that's beyond to the exclusion of a reasonable doubt, you'll have to decide if he's guilty of a lesser crime. And without going into those instructions of those individual cases, or excuse me, individual lesser included crimes, what you do need to know is that the lesser included crime to first degree premeditated murder is second degree murder and manslaughter. And the lesser included crimes in the definition of attempted first degree premeditated murder are attempted second degree murder and manslaughter. You'll have those instructions for your review. As I come to the conclusion of my argument, remember that if you believe Mr. Sampson might be guilty, it's not enough. If you believe he's possibly guilty, that's not enough. If you're pretty sure or almost positive that he's guilty, then the state hasn't met its burden. This case is premised on the theory of principles. We've talked about it in jury selection. Ms. Isber's talked about it. I've talked about it to you again because that's how critical it is. And although I believe that you will do everything required of you during the course of your deliberations, I would ask you to pay particular close attention to the principles instruction. And we are going to talk about this one at length. If Zvante Sampson helped another person or persons commit or attempt to commit a crime, Zvante Sampson is a principal and must be treated if he had done all of the things the other person or persons did if the state proves beyond a reasonable doubt the defendant intended the crime to occur. And there's not an or there for a reason. And the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. Again, dovetail that into the East Gun and Pawn video and look at it in real time and ask yourself whether you can apply that definition to anything that Zvante Sampson did in that span of time. For first-degree premeditated murder and attempted first-degree premeditated murder, remember, because it's very important, that the state must prove that the defendant intended that the killing of Suni Bell or the attempted killing of Willie Brown and Mary Harrison to occur. He intended a killing to occur. It talks about what would happen as regards to the lessers. Read that because that's important as well. And as it relates to shooting into a vehicle. In conclusion, with regard to the instruction, it's not necessary for a principal to know every detail of how a murder or an attempted murder or shooting into a vehicle would be committed, as long as the principal, Zvante Sampson, intended the murder or attempted murder or shooting at or into a vehicle to occur and did some act, said something that was intended to help or did help the murder or attempted murder or shooting into a vehicle to occur. To be found guilty of those crimes, it's not necessary for the state to prove that he knew another participant of the murder or attempted murder would be armed. Remember that you are 12 individual people and not merely a group of 12. You'll go back into that jury room to deliberate as 12 individuals together. You've, over certainly a lengthy trial period like this, had the opportunity to spend a great deal of time with each other. You ate together, at least some of you might, on certain days, all of you, who knows? But what you know about the people next to you and the people behind you certainly is far greater than you did as strangers before this. You may think that this is a group decision. Well, it's not a group decision. It's an individual decision for each of you. And when you do that, each of you has to determine and has to make sure that the state of Florida has proven every single element of every charge that exists as it relates to Zvante Sampson. You told me, and this all has to be done to the exclusion of a reasonable doubt. You told me in jury selection you'd remain true to that belief no matter what the circumstances are, despite the fact that you may be in a minority, despite the fact that you might be alone in whatever that conviction may be. I'd like to thank you again on behalf of Zvante Sampson. I'd like to apologize again on behalf of Zvante Sampson. You have a very extremely difficult task to begin as soon as these arguments are over. Thank you for your close attention. Thank you for your attentiveness. When I'm going to sit down now, the rest of the lawyers are going to have their opportunity to address you in closing argument, and then Mr. Terrier, Ms. Ismer, and Ms. Bonte will be doing what we call rebuttal for the state. I won't have an opportunity to speak to you again, and I'm certain that after your deliberations and after you reviewing all the evidence, in particular those things I ask you and implore you to look at length in your deliberations, that you will find that the state has not met its burden as it relates to convicting Zvante Sampson for premeditated first-degree murder, attempted premeditated first-degree murder. There was no conspiratorial act committed by Zvante Sampson that would warrant his conviction for conspiracy to commit first-degree murder, nor shooting into a vehicle. He's not a principal to these crimes, ladies and gentlemen, and he shouldn't be penalized in the worst way that our system knows for the acts of someone else, those acts that he's not responsible for. It's pure speculation. Thank you.
Mr. Hernandez. Whenever you're ready.
Thank you. Ladies and gentlemen, I also want to thank you very much again for your time, your attention, and your consideration of this so very important case. Please understand, just like the opening statements, everything that was said today by the state and by the defense attorney is not evidence. You have seen and heard all the evidence in the case, and your decision has got to be based on what you've already seen and heard. But this is our opportunity to summarize what we believe the evidence has shown or not shown. And as Mr. Gonzalez just made a reference to, this is our last opportunity. Each attorney has one chance to address you for the defense. The state will always have that opportunity to address you one more time after all the defense attorneys have sat down. Obviously, every attorney wants to have the last word, but what I want you to be very aware is that if the state in their rebuttal says something, and I don't want anyone to please think, well, how come the defense didn't come back and address what the state just said? And the reason is that they have the burden of proof, and as a result of that burden of proof, they get the last chance to address you. Now, my client is charged with counts 1, murder in the first degree as a principal. Count 2, attempted murder in the first degree as a principal. Count 4, conspiracy to commit murder in the first degree also as a principal. And finally, indictment, he's charged with shooting at or within or into a vehicle. Please keep in mind that all these charges against my client, he's being accused as a principal. He is not charged with count 6, which is actually discharging a firearm. Now, if we could start before we get into what was actually presented in this case, I'd like to go back and go over some of the important principles that must be followed by the jury in determining whether or not the state has met their heavy burden of proving their case beyond a reasonable doubt. And as we go through the evidence, please understand we're all taking notes. There is absolutely no effort to misstate anything. If I say something that you remember differently, please rely on your collective memories and your collective notes. But as we go through what was actually the evidence against my client, it's important to always keep in mind the things that you've already heard. The fact that the defense has absolutely no burden of proof. Every bit of the burden is on the state of Florida. And because of having no burden, and as you will be told again by Judge Fuson, is that the fact that the defense did not present any evidence or the defendant did not testify is not in any way to be considered by you against the defendant. And as we talked about, and Mr. Gonzalez just made reference to this, is that the burden of reason out is very, very heavy. The judge will define to you exactly what reasonable doubt means. And I paraphrased it once, and I'll try to paraphrase it again, is that if you have carefully considered all of the evidence, carefully and weighed it, and have an abiding conviction of guilt, then you are instructed to find the defendant guilty. But if you do not have that abiding conviction of guilt, or even if you do have a conviction of guilt, but it wavers and vacillates, you determine it's not stable. You say, well, maybe he's guilty, but yes, but what about this and what about that? If your feelings, it wavers and vacillates, and that's part of the definition of reasonable doubt, you are absolutely instructed, without a doubt, to find the defendant not guilty. And we talked about civil and criminal juries. Yes, in a civil case, if you believe a defendant, someone accused of something, being sued for something, if you believe that he's maybe guilty, possibly guilty, or even probably guilty, that's enough to find for the plaintiff. That has absolutely nothing to do with a criminal case. The burden of proving their case beyond a reasonable doubt is a very heavy burden that the state has. And as I said, the judge will give you the full definition, but it's important to talk about these things a little bit now so that we can evaluate what the evidence is or lack of evidence is against my client, Mr. Bedward. Each element has to be proven beyond a reasonable doubt, and you can determine reasonable doubt by the actual evidence that's been presented. You can determine that there's reasonable doubt for lack of evidence. You could say, well, the state presented this or that, but what else is missing? What about this? What else could have been done? Reasonable doubt can come from lack of evidence. Reasonable doubt can also come from conflict in evidence. And as I think I mentioned to you during jury selection, I can argue forever that my client is 100% innocent, but the word innocent never appears on a verdict form. You'll never be asked that question. The verdict form is going to say whether you find the defendant guilty as charged, guilty of a lesser charge, or not guilty. And that makes sense because that is consistent with the ultimate question is that you have for your consideration is whether or not the state has proven their case beyond a reasonable doubt? That's your question. And that's why you'll see the words not guilty, and I suggest that is the appropriate verdict, but you'll never see the word innocent on a verdict form. Also, please remember the fact that the state has filed an indictment and the fact that it's a vehicle, it's a piece of paper that must be filed in order to get to this point. But the fact that he is charged with this document is not evidence. And that we do, even though you have 5 defendants being tried together, you have 5 separate trials. My client is Jaylin Bedward, and of course I'll be trying to focus specifically on the case against Mr. Bedward. I know it's been mentioned several times, but I implore you that sympathy cannot be part of your consideration. We have a tragic situation of a beautiful 4-year-old girl who was shot and killed as a result of what happened on this day. But somehow you're being asked, it's part of your obligation as a jury to decide this case on the evidence, not on the obvious emotional sympathy that one would feel for any fatality, but specifically with someone so young and so much love and life to give. I also would ask you to, as we go through this evidence, and in your evaluation of the case against my client, not to speculate. Your decision has to be on the evidence that was actually presented. You can't fill in the blanks. If you find blanks, you can't fill in the blanks that the state has left you. Now, as I said, Mr. Bedward is not charged with discharging a firearm in this case. The state's theory of prosecution against Mr. Bedward is that he was a principal. They have accused him of being a co-conspirator. I suggest to you that what you have seen in this case against Mr. Bedward, there is no direct evidence that the defendant was a principal or co-conspirator in this case. There is no direct evidence of premeditation. There's nothing, no statements, no text, nothing in this case. Now, there's plenty of direct evidence that there was a shooting. There, you've seen the videos. That is direct evidence. You've seen certainly the testimony and photographs of the testimony of the medical examiners to cause of death and manner of death. There's a lot of direct evidence. But my suggestion to you is you've got to keep that separate because there's no direct evidence to the crucial issue in this case regarding Mr. Bedward. Did, in fact, he have any knowledge ahead of time or any evidence that he was a willing participant in some kind of criminal activity? To be criminally liable as a principal or co-conspirator, the state must prove beyond a reasonable doubt that the defendant, Mr. Bedward, had knowledge and was a willing participant in what happened on this day. And I suggest to you that there is no direct evidence to this whatsoever. So that forces the state to rely on circumstantial evidence. And circumstantial evidence is valid evidence for your consideration, but it needs to eliminate all reasonable explanations of innocence. If it proves their case beyond a reasonable doubt, circumstantial evidence is valid evidence. But I suggest to you that in this case, against Mr. Bedward, the circumstantial evidence that's been presented comes nowhere close to proving their case beyond a reasonable doubt. There may be suspicions thrown out. There may be inferences and suggestions. But to prove the case against Mr. Bedward, there's got to be a lot more than suspicion or inferences or theories of prosecution. Now, obviously it did not apply to this case, but in my cross-examination of Detective Zelaya, I asked him about criminal conspiracy investigations. That as an example, there are times where criminal conspiracy investigations have wiretaps. Now, obviously, that would not be applicable in this case, but that's just an example of situations where you actually have evidence, not just speculation, but actual evidence that a person had knowledge, that he had an intent, that he became a willing co-conspirator. It's not applicable in this case, obviously, but you can't consider it as lack of evidence because there is no such evidence in this case against Mr. Bedward. The value of statements, either recorded statements such as wiretaps or text messages or conversations to other people, is that many times that gives you evidence to decide what a person's state of mind was at the crucial moment when this offense took place, when the shooting took place. But here, I suggest to you, ladies and gentlemen, that does not exist in the case against Mr. Bedward. And that's part of what the argument is that lack of evidence can be a source of reasonable doubt. They may not tell you that, but the state basically, in so many words, is saying, well, you should draw from inferences based on these defendants being together in different vehicles when a fatal shooting took place. I suggest to you that this is not a situation where you can make guess or fill in blanks or speculate. There is no statements or criminal acts by the defendant in this case that shows knowledge, willingness to participate in a criminal conspiracy. Now, the evidence in this case also shows to you, ladies and gentlemen, that the defendant, Mr. Bedward, was totally cooperative with law enforcement. He agreed to speak with Detective Zelaya, and certainly having a constitutional right to remain silent, and he didn't, by law, he didn't have to answer any questions, but he answered all the questions. Now, you will be instructed of out-of-court statements that don't happen in court, that you can consider that statements made should be considered with caution and weighed with great care. But nevertheless, he answered all the questions. He identified himself as the driver of his car. He's the registered owner of that car. He was not trying in any way to hide that he was there, that he was actually driving his car. He admitted to possessing a firearm, but that firearm was never fired. The state is not contesting, as obviously they didn't charge him with that count, so they're not contesting the fact that my client never fired a discharged firearm. And the state is not contesting the legality of possessing that firearm. He had the right to possess the firearm, and he denied any involvement in any criminal conduct as he was questioned by the detective. He consented to the search of his residence and his car. There was nothing illegal found, nothing showing knowledge, nothing showing intent or willingness to engage in criminal conduct. There was ammunition in his apartment. But again, the state they didn't charge him with anything. They're not contesting the legality of possessing that firearm. The same thing with a handgun in the car. The defendant is not charged with illegal possession because it was not a crime. So you've seen this evidence, but please understand that that evidence in no way implicates Mr. Bedward with any criminal conduct. So, ladies and gentlemen, I suggest to you that what we have here is that Mr. Jaylin Bedward was merely present at the scene of a crime where a beautiful 4-year-old child was tragically and fatally shot. He was driving his car. The evidence, the testimony by one of the detectives is that the car didn't stop, it didn't speed up, it didn't slow down, it just kept going. And there were no shots fired from the driver's side of the vehicle. There is no evidence, ladies and gentlemen, that Jaylin Bedward knew a shooting or any type of violence or crime was about to take place or did take place. There is no evidence, ladies and gentlemen, that Jaylin Bedward physically or personally committed any illegal act. I suggest to you, ladies and gentlemen, that law enforcement came to the conclusion that the defendants knew each other and therefore conspired to commit a crime, basically guilt by association, that there was some type of coordinated effort as opposed to someone acting independently. Ladies and gentlemen, the two people, I and a friend of mine, could be walking down the street, and I see someone I don't like or even hate. I pull out a gun and shoot that person. My friend who was standing next to me is not guilty of anything unless there is evidence that my friend had knowledge in advance and did something to assist me. We don't have that in this case. There is no evidence that Mr. Bedward had knowledge ahead of time or did something to assist a criminal act. There are no relevant communications between any of the co-defendants before, during, or after the shooting. And as Mr. Gonzalez mentioned, this happened very quickly. This was not something that took a lengthy period of time. And in some cases, as I just mentioned, wiretaps. In some cases, you can have a cell phone analysis. In this case, we have we have the fact that there was communication or contact between different phone numbers, and you can have contact with each other is not proof, because an association or even a friendship does not equate to a criminal conspiracy. Text messages, which don't exist in this case, might if they are incriminating. Here we have no text messages or any communication, call it whatever communication you want, that Jaylin Bedward acknowledged knowledge of an illegal plan, or that he was in any way agreeing to any kind of criminal activity. And again, those are factors that you can consider. You can consider the lack of evidence as a source of reasonable doubt. Someone, ladies and gentlemen, can innocently be at the wrong place at the wrong time. Someone can be merely present at the scene of a crime. Someone can act independently, even if in the company of others. And I know you're tired of me saying it, but I'll say it one more time. As jurors, you cannot speculate about what somebody knew or did. You need proof. You need solid proof. You need identifiable proof beyond a reasonable doubt. And I suggest to you that that does not exist in this case. Now, as we said, we have a joint trial in this case. We have 5 defendants. Each defendant and each charge must be separately evaluated. And the evidence is different. There's some similarities here and there, but the evidence is different as to each defendant. I hope that I have accurately shown you why the state's evidence against Jaylin Bedward is sufficient to warrant being found guilty of any of the 4 charges that he's facing. Please take a good look at him separately. These references to they is not enough. Speculation is not part of the equation. And I suggest to you, ladies and gentlemen, that if you carefully consider the evidence in the case, what's been presented, but also lack of evidence, what has not been presented, what does not exist, and a conflict in evidence. If you do that, ladies and gentlemen, I suggest to you, as to Jaylin Bedward, there is ample reasonable doubt, and the only just and correct verdicts are verdicts of not guilty. Thank you.
All right, ladies and gentlemen, we're going to take a 10-minute recess before we begin with our next hearing.
All rise for the jurors.
These from St. Peter. Yes. So we had this terrible fracture case. He's just standing there, waiting for everybody to come out. And he goes, I don't build them, I just farm them.
Who person you're going to As I have the distinct honor and privilege of representing James Denson throughout this trial, I asked you last week to consider the circumstances of the killing and the conduct of the accused. Because we have 3 distinct vehicles that you've heard evidence regarding, and we have multiple different people who may or may not be before you today who were inside of that vehicle. And each individual person, you're going to have to decide what involvement they had based on their own conduct and their own conduct only. And you don't need to take notes on what is written on this that I'm using for display, but because you will be given a copy of all these things. But this is what it talks about when you have multiple defendants, multiple counts. And it says the charges against each defendant and the evidence applicable to him must be considered separately. And why is this important? On multiple occasions during our time here together, the government has used the word they as it pertains to evidence of intent, as evidence of overt action, and as evidence of a common plan. They masked up. They armored up. They went to war. However, because the law instructs us that you must take an individual analysis of each person's culpability as to each specific element of each crime, you'll be able to see that the analysis as it pertains to Mr. Denson fails. Because guilty by association is not a phrase that exists in this courtroom or back in the room when you go to deliberate. An irrational person person should question why, whether under the facts of this case, the prosecution has made a blanket over this courtroom with the word they. So let's talk a little bit about jury instruction as it pertains to murder in the first degree. The annotations here are all going to be mine. So you will be charged that to prove the crime of first degree premeditated murder, and I'm asking you in your minds when you're discussing it with each other, where I wrote in blue ink, to say, as to James Denson, the state must prove the following 3 elements beyond a reasonable doubt. And the reason that we do it this way is for efficiency. But efficiency and convenience cannot trump my client's constitutional right to a fair trial. And any confusion in this area, even if we're being overly cautious, cannot happen. So when I say to prove the crime of first degree premeditated murder as to James Denson, the state must prove 3 things. Number 1, that Suni Bell is dead. Okay, that's not going to be in dispute. But what will be in dispute is number 2, the death was caused by the criminal act, which I have highlighted, of James Denson, which I also have highlighted. And you see I put X's under here where it says and or. Because even though we'll talk about principal theory and that's something like that, you cannot hold my client accountable if he did not intend for these crimes to occur. The death was caused by the criminal act of James Denson. If he didn't do it, you cannot hold him accountable for it. Okay? And then there was a premeditated killing of Suni Bell, again, which is an element of the mind. And why, when we're talking about premeditation, has the phrases that I've used throughout this time been most important. Okay? The circumstances of the killing and the conduct of the accused. When discussing the principal theory, okay, again, this is not something where we can just throw a blanket over these proceedings and say, because the government has the principal theory available to them, that we can just say everybody is responsible for the actions of everybody else. Because, as I've highlighted for you in the instructions, it is still crucial that the defendant must intend for the act to occur, and you must be given evidence of that, and that the defendant did an act that was intended to assist somebody in actually committing the crime. And for first-degree murder, the state must prove that the defendant intended for Suni Bell to die. For attempted murder, as it pertains to Mary Harrison, the state must prove that James Denson intended for that crime to occur. Without intent and without action, the principal theory should not apply. And the same applies to the lesser included crimes alleged of murder in the second degree and manslaughter. Again, I ask you to, in your mind, state to prove the crime as to James Denson, we must show that the death was caused by the criminal act of James Denson. To prove manslaughter, that James Denson intentionally committed an act. And so on, whether it's an attempted murder, whether it's a shooting into a vehicle, there has to be an action taken by my client, James Denson. So how do we determine what is in the mind of a person? What is their intent? What's an overt act versus reaction? So let's look to 3 places. We've got the Jet or the Chevron gas station. We've got the stretch of Hillsborough Avenue between 45th and 42nd Streets. And then we've got Mr. Denson's home. So first I'd like you to go to the Chevron. And I think that to allege that Willie Brown's Infiniti drew the attention of my client at the Chevron when it was parked in an unusual location in a grassy lot with its lights off later at night, to think that James Denson's attention was drawn to that because he was offended somehow that these people were on his turf, I think that is somewhat outrageous and short-sighted. We cannot check our common sense at the door. We cannot forget about our life experiences when we serve as jurors. And I don't think that we can be ignorant of the life experience or circumstances of those who stand before us. I think we should similarly judge others through the way that they view life. And I think it's certainly reasonable in certain parts of town to view actions like that as something that can be a safety concern for you. So investigating the appearance of Willie Brown's Infiniti in an unusual spot is not evidence of a common plan or a scheme or an intent to commit a crime. The court is going to instruct you that a reasonable doubt as to the guilt of my client can come from the evidence, from a conflict in the evidence, or from a lack of evidence. And the evidence from the Chevron, from Detective Saleha, from the videos, tells us that Mr. Denson is not present when anyone carries a firearm, anyone displays a firearm, anyone loads a firearm into a car, anyone disguises themselves at all. He is out of the picture for all of those events. And where does he go? Where is he when all of these things are occurring? If you look at the video, you do see him running from the side of the store back off in a different direction. And where did he go? Well, according to Detective Saleha, my client, James Denson, went to his car. His car is not one of the 3 vehicles that exited the Chevron parking lot that night. He goes to his overview. If you look at if you look at the video from the Chevron, specifically states 56, it's going to be taken as you look at the 300. And when you're looking at that, it's going to show you that Mr. Denson is basically off to the side, okay? So small you can barely even see him next to it, but you'll see the reflective Nike insignia on his shirt, okay? And when he goes over there, and he's coming back over there, you're going to see the Chrysler 300 getting ready to leave the parking lot. That's the car that Mr. Denson ended up in the back seat, okay? Why is it important? Why is it the timing and circumstances going to be something that we should key in on? Why didn't he get in his car and why didn't he leave? Well, we know from Sergeant Lippold, the homicide supervisor that went to Mr. Denson's home to speak to him, that in the parking lot of his apartment complex on September 28th, that Mr. Denson tells him that at some point prior to that, he had locked his keys in his car, because Sergeant Lippold looked at his car. He's like, hey, why's your window broken on your car? He's like, hey, man, I locked my keys in the car. I had to break in there to get into the car. Okay?
Objection, Your Honor, that's not evidence.
I would just-
What the attorney said is not evidence, and you're not to consider as such. You continue.
So when relying on your own recollection of what was testified to, I would submit to you that it's a reasonable inference that James Denson didn't leave that night in his car because he couldn't. That as the 300 is backing out, he made a split-second decision to enter into that vehicle to get in and leave the situation at that point. Okay? So let's talk to you about place number 2, the stretch of Hillsborough between 45th Street and 42nd Street. So looking at State's Exhibit number 20, which is where we have our measurements on Hillsborough. We've got all the evidence markers here. We've got it zoomed in here, right around 43rd, and the point of reference where the vehicle struck. And then to the west, we've got additional casings, okay? And then we've got measurements. And so we can tell, based on the information that we get from James Kwong, based on the markings that were taken, that number 43 and number 44 are the 2 shell casings that are attributable to Mr. Denson's firearm, okay? And we can tell from looking at the measurements that number 43 was located almost 100 feet west of the point of contact with the telephone pole, and number 44 was about 129 feet west of the telephone pole. Why are these measurements important? Okay, so James Kwong came from the Department of Law Enforcement, the ballistics expert, and he gave us an education about what happens when a semi-automatic firearm is fired. You have an ejection of the casing, and it's going to go slightly to the right and slightly behind. You're going to know that it's in a tunnel or a vacuum. It's going to go between 0 and 15 feet away from the point that it is fired, and then even though things like people kicking them or vehicle traffic can affect where the casings eventually land, along with the type of terrain that they land on, we can probably take away a reasonable inference that these casings were not run over. As you saw pictures of the ones that got run over, these were not defected or deformed in any way. So we know that the scientific evidence tells us that Mr. Denson shot a handgun anywhere from 100 to 130 feet west of the accident site. Doesn't tell us in which direction he shot. And I would argue that the majority of the damage to Willie Brown's Infiniti was to the rear and to the driver's side of that vehicle. That the critical shots are going to be found and the critical number are going to be found in that direction. You don't have a windshield that's pierced by a bullet, and there, are other things in that area that the police found it noteworthy to document. For example, if you're looking at State's Exhibit 1EQ and State's Exhibit 1ER, where you have evidence marker number 40, okay? And evidence marker number 40 is what they believe is suspected gunfire damage to a shop that's located at 4172 East Hillsborough. So why are they documenting this damage? It's because we think a bullet may have struck this building, okay? Importantly, when we're looking at where the evidence markers are, you have evidence marker, you have the point of reference right here where this happened. You have the evidence marker 40 up here, and then 43 and 44 as it corresponds to the shell casings as it relates to Mr. Denson are similarly located to the west. So if we're focusing on intent and overt acts, we can't guess, we can't assume. But I would submit to you that all of the evidence in the situation is going to tell you that there is zero way that the state can show that any specific shot from Mr. Denson was inside or at the direction of that infinity. So let's go back to place number 3, Mr. Denson's apartment complex. So let's paint the picture a little bit. You have multiple homicide detectives that are coming to your home. This is not a casual conversation, okay? And if you recall, this is the home in which they found a Coach mini backpack and Nike slides, because they were trying to say, okay, was Mr. Denson at the Chevron on August 22nd? And he told them that he was, okay? He also, was advised, you're not free to leave. But at the same time, we can't, or you are free to leave, excuse me, but at the same time, we can't have you just sitting on your couch while we were cataloging and collecting evidence as part of this homicide investigation. So they're in the parking lot. Detective Celaya tells James Denson, you've got the right to remain silent. You've got the right to the presence of an attorney. You don't have to speak to us at all. You can exercise any of these rights at any time. And knowing these rights, do you still wish to speak to me about the shooting at the Jet? And he says yes. And he was asked, you got a concealed weapons permit, right? He says yes. Do you own any guns? Well, yes, I pawned my 9mm at East Tampa Gun and Pawn. I got a loan, because when you pawn something, you can outright sell it to the pawn shop, or you can get a loan on it. Money's tight, but I plan on getting it back when I can. So this is the first time that the police are aware of any firearm that could be involved in this case. And my client gave that information up freely and voluntarily, not by accident, not by trick. And as we discussed before, this is the exact opposite of a guilty conscience. A person who consciously took part in, participated in, or otherwise intended for the murder of one human being to occur or the attempted murder of another person, they're going to get rid of that weapon. They're going to do that so quickly if they're involved in the situation, you wouldn't be able to believe it. You're going to throw it in the river. You're going to give it to somebody else. You're going to sell it on the street. You're going to get money for it. You can ask somebody else to sell it under their name. You don't go to the pawn shop directly next to the Jet, the Chevron, where all of these events started. Hand over your driver's license, hand over your fingerprints into a database that can be searched by the police, and get a loan and go on your way. And we know Mr. Denson led the police there. Number one, because Detective Celaya, the lead detective, he told us. I know Sergeant Lippold had a little bit different recollection of the order in which these things happened, but we know that Detective Celaya was accurate, because looking at State's Exhibit number 33, which is the pawn ticket, see, when you take something into custody, they put an evidence sticker on it. And the date of this one here is September 28th of 21, which is the same date as State's Exhibit 28, which details the search warrant that occurred at Mr. Denson's home. So we can know with confidence that this is actually what happened, okay? He pawned the gun 25 days later, not 28 hours later. He cooperated with the police in this instance. He cooperated with the police in others. He gave his passcode to them when they found his cell phone. And by the way, when they searched his cell phone, you don't have evidence of one web search, one specific text message saying anything about this, one specific group chat saying anything about this, one specific photo connecting him in any way to do this, and all that data was on the phone. It wasn't wiped, it wasn't reset or anything like that. It was there for the taking on September 28th, okay? There's no evidence to hide, all right? So much has happened over the last 4 years to develop this case. And we all know that the standard to make an arrest or initiate a prosecution is much different than the burden that we have here, which is the highest under the law, under our Constitution. So at the time that Detective Celaya did confer with the prosecutors to bring this charge, I asked him if he had Detective Alverson's mapping of the scene and where the shell casings were found available to him. And he said no, he did not have that information available to him. Would it have made a difference then? I don't know. Sometimes you can't put the genie back into the bottle. But I do think that it should make this group think twice about if that information was available, it would matter then. But I definitely think it should matter now. If we were considering where the shell casings from Mr. Denson's gun were found, his cooperation with law enforcement, and the fact that he certainly hasn't had anything to hide. So let's talk a little bit about one final thing. We're going to talk about how you be instructed on the law about reasonable doubt, okay? What the law is going to say that after you carefully compare, after you weigh, after you consider all of the evidence in this case, if you do not have an abiding conviction of guilt, meaning if you have a conviction, but it's one that goes back and forth, it wavers and vacillates, then the doubt is reasonable and you must find the defendant not guilty. If you're going back and forth regarding whether or not you should find him guilty of these charges, that is a reasonable doubt and you must find him not guilty. Because this is the only opportunity that I'll have to speak up for Mr. Denson, I'll ask each of you to think to yourselves whether it's during the prosecution's rebuttal or whether it's in the jury room itself during your deliberations. And when something is brought up that makes you think about James Denson, I would ask you to say on his behalf, what would Mr. Fischetti say if he was able to speak to me right now? You know, Mr. Terry spoke during jury selection about running yellow lights and how that is an example of premeditation. That was it enough time to make a decision to act? But isn't that really a reaction when you go through the light? And later on, when you have the chance to think about it, when you have the chance to think to yourself, to reflect, maybe you say that it wasn't the best idea that I did that. Because an overt act, what we're talking about here, that's intentional. But a reaction, like when you go through a yellow light in that short time frame, that is unintentional. And because the government hasn't proven otherwise, I would ask you to find my client not guilty. Thank you.
Mr. Sonardi?
Please, the court. See.
Good afternoon. As you will recall, my name is Nick Sonardi. I represent Mr. Andrew Thompson, and on behalf of Mr. Thompson, the gentleman sitting to my left is Scotty Sonardi, and Katie Rain, we want to extend to you our appreciation for your services here. I know it's been very difficult, very imposing on your lives, and I'm sure at points in time you kind of feel like cattle, hurry up and wait, come back, leave, come back, but we do appreciate your time and your effort and your concentration. This is the last opportunity I will have to speak with you. As the other attorneys have indicated, the state has the final word. They will be the last ones to speak. What the judge has indicated, I believe a couple of other attorneys have indicated, what I say, what the state says, other attorneys say is not evidence. What is evidence is what has been introduced by the court or from the witness stand. That is the only evidence. If I indicate something to you that does not coincide with your recollection, use your recollection. It's not my intent in any way to mislead you or misinform you. There's been a lot of testimony, a lot of things going on over the last 6 or 8 days. So if my notes are not reflective of your recollection, use your recollection. Your recollection is what is important. Again, the charging indictment is not evidence. It's simply the means by which to get these gentlemen into court so that a jury of their peers can make a determination as to whether or not the state has proved their case beyond and to the exclusion of every reasonable doubt. Again, my statements are limited only to Andrew Thompson. We do not represent any of the other individuals sitting here, so my statements only apply to Andrew Thompson. As I indicated on our opening statement, which was kind of an outline of where we thought the evidence was going to go or what it was going to show, is that this was then and is now, as it applies to Andrew Thompson, a circumstantial case. There is no direct evidence implicating, beyond and to the exclusion of every reasonable doubt, Andrew Thompson in any of the 6 counts that the state has charged. So what is the evidence, or lack of evidence, or the circumstantial evidence? Well, we can start with the witnesses. All right? The state called a number of witnesses, obviously, and I guess the most important ones was Willie Brown and Mary Harrison. What do they add to allow you to believe that Andrew Thompson was somehow involved in the shootings in this incident that occurred? Nothing. They can barely identify the cars, barely identify any shooters, barely identify anything other than they believe they were being shot at. And I believe Mary Harrison identified a black car as one of the individuals, one of the vehicles that was shooting at her. Detective Nightlinger, he confirms that 3 vehicles left the Chevron gas station that evening around 9 o'clock in the evening, and that 1 vehicle returned. I believe he's the one that indicated that the number of minutes that expired from the time the last vehicle left to the time that 1 vehicle returned. However, that vehicle did not include Andrew Thompson. Okay? He was not in that vehicle. Detective Albertson also indicates there were 3 suspect vehicles that left that Chevron. He believes one of them was a black in color vehicle. And of course, the lead detective is Detective Salela with the Tampa Police Department. He obtained a number of the videos. Some of the other individuals obtained other videos. I believe there was 8 videos obtained. Some of the 8 surveillance locations, some of them had multiple videos, but at least 8 surveillance locations that videos were obtained. It's the state of Florida's position that Mr. Andrew Thompson is somehow involved in a conspiracy to commit first-degree murder. What I submit to you is that it's clear on the videos, and you've seen them and will continue to see them, that there are a number of people at that Chevron station, at least 9. We know of at least 9 individuals, but only 5 have been charged with conspiracy. The actions that the state attributes to Andrew Thompson and others that constitutes this conspiracy also applies to the other 4 individuals that were there at the Chevron station. However, they're not charged with any conspiratorial actions. For whatever reason, the state chose 5 individuals, but not the 9 that we know that were there, that left in the 3 vehicles. We know there were 2 in one vehicle, allegedly 3 in another vehicle, and 4 in the second, they're calling it the second vehicle. They were all together. Their actions are the same, consistent with the actions, alleged actions of Andrew Thompson that allegedly constitutes a conspiracy. Why aren't the other 4 individuals charged with a conspiracy? All right. Obviously, and I'm not going to go over it, you all have seen them, you all have heard them, the evidence in this case, as it applies to Andrew Thompson, is predicated solely on the videos. That's it. No other evidence whatsoever. It is the videos, and the videos alone. Now, what's important about that? What's important about that, obviously, is not what the state thinks the videos show, or what I think the videos show, or even what Detective Salela thinks the videos show. What's important is what you can determine those videos show. Okay, and I submit to you, you will find that it's very difficult, if not impossible, to identify exactly what is transpiring in the videos other than cars going up and down Hillsborough Avenue. Okay, no one can be identified from any of the surveillance videos in any of the cars. And I submit to you, it's difficult, if not impossible, to identify the vehicles themselves. What vehicles are doing what at what time. The state has a theory. Detective Salela has a theory, and they presented that theory. But it's your duty and job to sit and review those videos and try to make a determination as to what is on those videos and what evidence applies to Andrew Thompson. The allegations by the state as they apply to Andrew Thompson is that he was allegedly the occupant of the Chrysler 300. There's a Chrysler 300 that's involved, allegedly involved. And I submit to you there is no evidence whatsoever, because that car was taken into evidence, processed, etc. There's no evidence, physical evidence, that connects Andrew Thompson to that vehicle. No prints. There is the evidence of 40 shell casings that were processed from the scene that the state did a wonderful job of identifying where they were all along Hillsborough Avenue, did them by color coordinated them and everything else. Those shell casings were processed for evidentiary value, including DNA, swabbed. You remember the ID tech that swabbed all those shell casings? There was nothing that came back that implicates Andrew Thompson with the shell casings, nothing whatsoever. Neither were there any fingerprints. There was a lot to do about ballistics. That is, Kwong, the ID tech, or the ballistics expert, opined about the shell casings, et cetera, went through a big dissertation about the shell casings. He is an expert in ballistics. And there was a lot to be done with, I believe, Detective Alverson and Detective Salela about muzzle flashes. We heard a lot about muzzle flashes, okay? Whether or not you can determine or distinguish between a larger, allegedly a rifle versus a smaller one. Well, Mr. Kwong is an expert in firearms. He was never asked to review the video and make an expert opinion as to what weapons were making what flashes. There were no guns attributable to Andrew Thompson. There was no guns recovered. The only guns in the car that he's alleged to have occupied, and that was Jaylin Bedward's car, was the box in the back, but that was not Andrew Thompson's vehicle, was not his box. There's no connection between he and the box that was found in the back of the car, of the silver Mercedes, silver Chrysler. If you'll recall, Detective Salela came in contact with Andrew Thompson at his apartment sometime after the incident in Brandon. There was no evidence, anything of any evidentiary value recovered from Andrew Thompson's residence at the apartment. There were no any kind of incriminating statements. In fact, Andrew Thompson voluntarily identified himself on the video at the Chevron gas station. Okay, voluntarily said, "Yeah, that's me." There are no, other than him identifying himself, there are no statements incriminating by Andrew Thompson in any of the incident involving Suni Bell. I think what's very, very critical as it pertains to Andrew Thompson is the phone data that was introduced by Detective Van Hess and Detective Boers with the Tampa Police Department that did the cell data reports on Mr. Andrew Thompson's phone. And as we know, this is State's Exhibit, Composite Exhibit 45, and this is the phone data, if I have it, for Andrew Thompson. And what does that display? I believe the red and blue dots that you see there obviously are where the incident occurred. That would be here and here. I believe the red is where it allegedly started. The blue is where the incident stopped. The circle that you see is the cell data indications from what Detective Boers was able to obtain. And those are for, so we're clear, that data was from 9 o'clock p.m. to 9:10 p.m., and the first ping was 9:09.55, which is a good distance from where the incident occurred, and there are no pings in the area where the incident occurred. What's interesting is it is right over I-4, which goes where? To Brandon, which is where Detective Salela came in contact where Andrew Thompson lives, in Brandon. So I submit to you the phone data puts Mr. Andrew Thompson at or near I-4 during that 10-minute time frame because it didn't ping anywhere else around Hillsborough between 43rd and 45th Street. There are 0 calls between Andrew Thompson and any of the other defendants during the time period of this. I believe one of the detectives said, believe there was not on Andrew Thompson's phone, on someone else's phone that's alleged to have come from Andrew Thompson's phone some 2 hours after the incident. That's the only connection between Andrew Thompson and the other individuals. Based on the circumstantial evidence of Andrew Thompson getting in the vehicle, there is no other evidence implicating Andrew Thompson in the tragic death of Suni Bell. As a result of the charges, and I'm not going to read them all because you've heard them 2 or 3 times, and that is the principal instruction basically says that Andrew Thompson had to have participated that he intended the crime to occur and did some act in furtherance of the crime. The only act that we can establish, that the state can establish beyond a reasonable doubt, is that Andrew Thompson entered the car. That's it. There's no guns attributable to him. There's no evidence attributable to him that he's identified in any time inside the vehicle. And other than entering the vehicle, there is no evidence of any act committed by Andrew Thompson. And what about the criminal conspiracy? Again, I'll reiterate that there were 9 people, allegedly 2 in one vehicle, 4 in another vehicle, and 3 in another vehicle. There were 9 individuals, but the state has elected to charge only the 5 defendants that are here today with conspiracy. And again, their premise is their actions at the time on the video indicates a conspiracy. I submit to you to commit murder. I submit to you that the actions then are the actions of all 9 individuals and not of the 3 individuals. And I submit to you, the 5 individuals, but I submit to you that there is no evidence of a conspiracy. The actions are of a number of people, 9 people at a Chevron gas station that are apparently moving around and talking. You can make your own determination, but there is no agreement. There is no agreement. And as it applies to Andrew Thompson, there is clearly no intent that there be a murder, and that there is no agreement between he or anyone else to commit a conspiracy to commit first-degree murder. And again, you will have with you in the jury room all of the instructions, which will include lesser included, which are second-degree murder, attempted second-degree murder, etc. And if you find that the state has failed to prove the primary charges beyond to the exclusion of every reasonable doubt, you have the right to determine whether or not they have established lesser included offenses: second-degree murder, attempted second-degree murder, manslaughter, attempted manslaughter, etc. You have the right to make those determinations. Okay. As I indicated in the original opening statements, however many days ago that was now, this is a circumstantial case. That has not changed. There is no direct evidence, none whatsoever. The only direct evidence in this case as it pertains to Andrew Thompson is that he was at the Chevron gas station. That's it. His phone records contradict that he was anywhere near the scene of this horrible incident. Okay. The only evidence, direct evidence, is Andrew Thompson being present at the Chevron. There's no guns. There's no physical evidence that connects Andrew Thompson to this horrible episode. I submit to you that because of the lack of evidence, the conflict in the evidence, that you should return a verdict of not guilty as to Andrew Thompson. This should not be based on any sympathy on your part in terms of finding somebody being held responsible for the horrible death of Suni Bell. But the biggest tragedy of all would be to return a verdict of guilty for an innocent defendant. I ask that, based on the lack of evidence, the conflict in the evidence, that you return a verdict of not guilty as to Andrew Thompson. Thank you.
Mr. Bradley.
Good afternoon. Over 30 days before any arrests were made in this case. That's a testimony that you heard from Detective Salea, way longer than the first 48 hours after the incident involving Suni Bell. You heard his testimony about the media coverage. In fact, Ms. Ismer showed you the photograph of Suni Bell that was used to try to get help from the public to solve this case. As you can imagine, with the death of a 4-year-old, there was tremendous community pressure to make an arrest. That's what led to what you've witnessed these past 2 weeks: assumptions and speculation. You heard about the police responding to the incident scene and how there were no independent eyewitnesses. You saw a still shot of the body cam where there were civilians out there trying to render aid to Suni Bell. But there were no witnesses from the Chevron or from any of the cars driving up and down Hillsborough or any of those individuals that were there that were able to help police identify who was involved in this case. That has continued throughout the investigation. There was no active pursuit of a suspect that evening. There was no car that was being followed. And so they were left to look for video evidence in this case. And they collected that surveillance that you've seen. They also collected evidence from the scene that was pretty much limited to casings that were on the road. Detective Salea went and spoke to Willie Brown and Mary Harrison, and they were not able to identify who shot at their vehicle that night. And you heard that same testimony when they came into court. They said it might have been a black car, that they heard shots. Remember, police had all of this video surveillance pretty quickly. Detective Neitlinger testified about it. Detective Salea, the first responding officers testified about the evidence that they collected when they were out there. Yet no charges were made in this case for over a month. When law enforcement started to review the video, they determined that there were 3 cars potentially involved. Now you have the video for you to determine who's involved in this case. As you've heard previously, no one from the second car is charged, and they know who was in that car. They focus their attention on the actions of individuals at Chevron. And Ms. Ismer and Mr. Terry and Ms. Zvante, they presented the individual video of the different people that are here today charged in this case. Pay attention to the video of Mr. Hammond, how he's playing dice when the 3 individuals go into the field and across the street to look and point. Also pay attention to the video surveillance that you saw of who the state alleges is the first car turning south on 43rd Street. That car was not in the area of the other vehicles when Suni Bell was shot. That's undisputed. She was alive when Willie Brown got out of the car and Mary Harrison started to drive. That's been consistent with all of the testimony that you heard. There was testimony that you heard from Mr. Kwong and diagrams that were submitted. He told you that there were several casings and the state made a point of excluding that one casing as being weathered and not part of the case. But even aside from that, he told you that 5 different firearms were discharged. He said 4 9mm and 1 rifle. There were 4 people in that second car and 3 people in that third car, which is a total of 7 individuals. That would be enough for there to be 5 shooters and 2 drivers with those 2 vehicles alone. The state in this case is charging only 3 people as potential shooters: Mr. Hammond, Mr. Denson, and Mr. Thompson. And you already know from the evidence that there's more than 3 shooters involved. And we know who's in that second car. Detective Salea testified to that. Maxwell Bedward, Kamani Bedward, who's the black male in the white shirt that we pointed out in the video, who's reacting to the vehicle, Cedric Brown, and Devin Sampson, the black male in the red shirt. And I had Detective Salea point out who those individuals were in that video that you're able to see. And the state wants you to believe that they're not charged simply because they don't identify themselves. Is that how easy it is to avoid getting arrested for first-degree murder? Does that make sense to you? And pay attention to what the video is, because the state wants to try to minimize that second vehicle and say, well, we're being overly cautious. We're only charging the people that we have the most evidence on. But pay attention to the evidence if it's all the same, and as Ms. Ismer argued, that they didn't have beyond a reasonable doubt for the second car, then how do they have beyond a reasonable doubt against Mr. Hammond? You can see that video from the Chevron that looks like Kamani Bedward, the individual with a white shirt who reacts to the vehicle, also looks like he has a gun. Detective Salea testified that muzzle flashes came from that second car, but the state didn't show you that video or go over that with you. And the muzzle flashes are for you to decide when you watch the video. You can watch it and make your own determination from the evidence, because the instruction tells you you can believe any, all, or none of the witnesses and their testimony, and that includes law enforcement and experts. Remember that Detective Salea is the only person that testifies about muzzle flashes from the first car. And why is that? When Detective Alverson came in and testified at great length about muzzle flashes from the third car. Remember when Detective Alverson talked about what can impact what you're able to see in the video, lights reflecting. And pay attention to that video and what you all determine is coming from vehicle one. Also, pay attention to the positioning of the cars and what was testified to. When Willie Brown came in, he testified that he didn't see a gun, he just heard shots from a car that was supposed to be right next to him. And when the state is showing you the video of what they're determining to be vehicle one, remember to pay attention, because there's other cars that are also going. Is it possible that Willie heard the shots and that he just noticed a car that was in front of him? Is it possible that those other cars were also involved? Is it reasonable that he did not see a gun or a shooter if the car is that close to him, firing multiple rounds? Mary Harrison testified also, and she did not see a gun or a person shooting either. They both testified to you that someone was chasing Willie Brown down the street. And you didn't see any video verifying that. But you can take all of that into account when determining a witness's credibility. When you watch the video and from the testimony, you know that the first car left the Chevron and returned in less than 2 minutes. That's undisputed. When the casings were located at the scene, they were later swabbed for potential DNA testing, and that was never. You know that the first car left the Chevron and returned in less than 2 minutes. That's undisputed. When the casings were located at the scene, they were later swabbed for potential DNA testing, and that was never submitted, so you don't have the results of that. No fingerprints were lifted to connect anyone to that evidence from the scene. You heard about clothing from Mr. Hammond's residence, and there was no testing or any kind of examination done on that. Pay attention, too, to the diagram of the casings. Now, you heard from the state's own argument that their only theory is that Zvante Sampson's car could only be responsible for potentially the first group of casings. And this is the diagram. And as you go through the diagrams, there's individual diagrams for each group, and then there's an overall one. And that's why I went over that with Mr. Kwong, because in the overall one, you cannot really tell the difference between the fuchsia and the red. And why is that important? In this diagram, the red are group one. And what do you have within group one? You have casings 10 and 11. And they are fired from a different gun. Why are those mixed in with the casings from Group 1? Doesn't it make more sense that there were 2 guns from one car being fired at the same time, and that's why they overlap? That's for you all to decide, because that would mean that those shots are coming from a different car than Vehicle 1. An uncharged car. Remember that Detective Salea testified that everyone starts running to the vehicles in the Chevron video after Vehicle 2 arrives, which is also an Infiniti. We know that there are only 2 firearms that have been connected to those casings that we've seen. James Denson's firearm that he pawned at the pawn shop and that was recovered and connected to the 2 casings. And then you heard very late about a second firearm that was recovered on Raheem Bryant in November of 2021. That gun is not only connected to the Group 3 casings, but also to the projectile that was found inside of Willie Brown's car. The state wants you to believe that Mr. Bryant was excluded because Detective Salea reviewed the video and he could not have been on there. Watch the video and pay attention to what he said when I simply asked him, okay, what does Mr. Bryant look like? And all he could tell you was black male. And you saw him shuffling. And he said, well, he's a black male. That's who they want you to rely on, excluding that individual. How about evidence? What about any follow-up investigation on Mr. Bryant? What about his cell phone? Did we get his records to determine forensically where he was on that day? No. And why was that not done? Because it doesn't fit their narrative. It makes things messy. If there's not enough evidence against Mr. Bryant or everyone in Vehicle 2 that we've identified, then why is there enough to convict Mr. Hammond? They need you to lump everybody together. That's why we're in trial together. That's the only way to convict Mr. Hammond in this case. But that is not what the law tells you to do. You must consider Mr. Hammond individually and each count he is charged with separately. That first car, even on their best case, is not there when Suni Bell was shot and killed. They had turned. There's no evidence to support a conspiracy to murder conviction against Mr. Hammond. They're relying on assumptions and speculation, and you agreed to follow the law and base your verdict on evidence and not emotion. And that's what we're asking you to do, to listen, to follow the evidence, and to find Mr. Hammond not guilty. Thank you.
Mr. Terry.
Ladies and gentlemen, I'm in a unique situation, and one that after 33 years as a prosecutor I've never had before, which is that I now have to rebut 5 experienced criminal defense attorneys who have all gotten up here and talked to you. Very rare to have to rebut 2, much less 5. So bear with me. I don't intend to keep you too long because you all have already heard and seen all the evidence, but I think there are some things that they said that do need to be countered. So first of all, one of the things that strikes me, when I was young, I used to hear this a lot more when I was younger than I do nowadays. I'm not sure what that says about me or the world or whatever it is. But when I was young, I used to remember hearing, my parents or other people say, actions speak louder than words. I'm not sure if you've ever heard that phrase, but that was a common phrase when I was growing up. Actions speak louder than words. A number of these defense attorneys here have told you and talked to you like, well, we don't see any agreement, there's no text messages. Well, of course there's not, they're all standing next to each other. We don't hear a wiretap. Well, of course not. This all happened, this conspiring all took place within that brief period of time while they were in that Chevron. Actions speak louder than words. Look at the actions of those individuals. What were they doing at that time? Watch it. It's very clear. The victim's car is driving by, and immediately you see 3 of them run out to that field to check out what's going on, including Zvante Sampson goes out there as well to look. And they go out there and they look. James Denson actually goes way across the street to see exactly where it's parking. And their attention is immediately drawn to that car. And then they're going back. James Bedward is so excited running back that he actually trips and falls. And they're all getting animated. You can watch that video. You can sense it. You can feel it. You can see it. They're pointing. They're waving. All of those actions indicate a common purpose. They are all deciding what they're going to do. They are all getting together, and they are all planning to go after that car and shoot and kill whoever is in that car. There is no doubt about it. Watch their actions. Yes, we can't hear what they're saying, but look at Zvante pointing at the car as it's going by. Look at him when he's in the driver's seat going, come on, let's go, let's go, let's go. What is he doing? He's trying to get them to hurry so they can catch up that car and shoot that car. Actions speak louder than words. Those actions, the way they all got there, the way they waited until the second car showed up before they all left together. 3 cars loaded with guns. You saw them all grabbing guns. Actions. They're all getting, what are they getting those guns for, ladies and gentlemen? Just to play around, do a little target practice? They're all arming themselves. They're all watching that car. James Denson, who Mr. Fischetti wanted to say, oh, well, my client, what was his conduct? What did he do? You know what he did? He was the one who went the farthest down there to watch that car. And he came running back to tell him what that car is doing, where it is, where it's going to happen. And if you watch him, he goes behind the dumpster, well, where they keep all the guns. And he's there right next to Quandarious Hammond, who's holding the gun. They all knew what's up. They all knew the game. They all knew what they were going to do. There's no question about that. Mr. Denson goes back to his car. Why do you think he went back to his car? To get his baby, to get his gun. He grabbed his gun and goes running back and jumps in the car. He was not going to be left out of this. Watch the excitement. Look at the people left behind, cheering him on. Go get him! Woohoo! Watch them. It's incredible. They're all geared up and excited. They're all working in unison. And we say they because it is a they. Yes, you are, under the law, required to consider each one of their guilt or innocence individually. But in this particular case, especially since they're charged with conspiracy, you have to look at their actions in concert and what they're doing together. They were coordinated. They knew what their purpose was. They knew what they were planning to do. They each followed each other out of that chevron, and they went. There were a lot of cars. There were other cars on Hillsborough Avenue. All 3 cars went to one particular car and shot it up. That wasn't a coincidence. They all left from the same spot, loaded with guns, and they all went after the exact same car. Because they had talked about it. They had gotten together. They knew what they were going to do. You see the guns. You see that AR rifle that Jaylin Bedward's walking around with. You see the gun that Quandarious Hammond arms himself with. We showed you a picture from his phone the day before with that gun, or the picture of the gun. They knew exactly what they were doing. And their purpose and their intent was to kill whoever was in that car. And I said to you in opening, and I say to you right now, I don't believe they knew Suni Bell was in that car. I don't believe they were targeting a 4-year-old girl necessarily. But they were targeting whoever was in that car. And sadly, it happened to be Suni Bell. They had a premeditated intent to kill. They thought about it. They went to get their guns. They had plenty of time while they were all sitting there ruminating about the car and what it's doing and everyone watching it. And then when the time came to load up, you can see how quickly they get out of there. And they take off. Zvante Sampson, who's not here, but Zvante Sampson was leading the charge. He was driver of Vehicle 1. Only 2 people were in that car. Zvante Sampson and Quandarious Hammond. Hammond was the passenger. We see them get into the car. We know that Zvante was the driver. He admits to being the driver. We see Quandarious Hammond get in there. He admits that he was a passenger in that car. We watch them take off. We watch them drive off. We watch them after they make that U-turn, they start to slowly to catch up with the victim. What does Zvante Sampson think is going to happen when he brings a man in his car loaded with a gun and they chase down an individual vehicle? Of course he knew they were going to go there and shoot that car up. Of course he knew that was the intent. Just driving for a little joyride. He comes right back. They clean up and make sure they pick up all the guns that are left behind the dumpster, and then he drives back over to that little house over there where he meets back up with Quandarious Hammond. His sole purpose was from leaving that Chevron was to track down that car and shoot the occupants of that car. Sole and only purpose that Zvante Sampson had. And Quandarious Hammond was his right-hand man, the shooter. And we know that it was that car that shot. Miss Bradley got up here and tried to make some innuendo or that maybe it was the second car. We know it's that car that shot because we hear the shots on the Power Electric video. You all can watch that Power Electric video and listen to it. You don't even see the second or the third car until after the whole series of shots. So we know that that first grouping in red that was shown to you were the casings fired by Quandarious Hammond, the very first car. And we know that car was shot because we hear the gunshots before the second and third cars ever there. And Willie Brown tells you he gets out of the car. And it was a dark Infiniti similar to his car. And he gets out and he runs. Why is he running? Because the car's getting shot. And that's before the second or third car are even in the picture. There's absolutely no question that Quandarious Hammond left those casings, those very first set of casings that he fired at that car. And they want to make a big issue about Suni Bell still being alive. So, well, he must not have killed her. All we know is that Suni Bell screamed and was saying, "Mommy." Do we know if she was screaming in pain? Do we know if she'd already been hit? We don't know. Was she alive for that brief minute or two or seconds? Yes, because she was making some statement or saying something in the back seat. But either way, whether she was alive or she had already had their fatal wound, the fact of the matter is that Quandarious Hammond with Zvante Sampson were the very first car to shoot at that car and basically disable it for a moment, giving the second and third car time to catch up. And watch that Power Electric video and listen to how fast that second and third car go by. Those engines revving. It's powerful. And then after they go by, you start to hear the other shots. Also, with Zvante Sampson's car, watch as the car's approaching. It's going at a very high rate of speed because it's got to catch up with Willie Brown. But if you watch on that Power Electric video, you'll see the brake lights coming on. Why? Because he's slowing down enough to give his partner time to shoot out the car and make sure he's got time to shoot that car. Those brake lights coming on are an indication clear as day, remember actions speak louder than words, that Zvante Sampson knew what they were about to do. Else why is he slowing down right as he's approaching the victim's vehicle? Because he knows Quandarious Hammond's got that gun and is ready to go. And when I tell you, ladies and gentlemen, that actions speak louder than words, in this particular case, those actions are shouting. They are shouting at you. I urge you to watch that Chevron video as much as you want. Slow it down. Watch the individual ones. See what they all do individually. The one thing that you cannot, it's impossible to not take away from that is the excitement, the energy, the building as they were getting ready to get in those cars. They knew what they were about to do. They were about to go on a hunt. Pure and simple. They were going to go hunt down whoever was in that car and shoot them up. And you can see that excitement. Watch it. The people cheering them on as they're leaving. It's crazy. They were about to go take a human life. These people are cheering them on. All for what? Because Willie Brown got lost trying to find a salon for a party? Mr. Gonzalez wanted to make some insinuations that maybe Mr. Brown was up to no good. Maybe he was going to go buy drugs. So what? Does that just mean he deserves to get shot and killed? Because he was going to go to Corey Brown's to buy some drugs? Buy some marijuana? He was going to Corey Brown's for this after party. He couldn't find it. He didn't know where it was, and so he happened to be at the wrong place at the wrong time next to these men. That was all it was. It's as simple as that. And Mr. Gonzalez wants to say, well, I don't know, he didn't even know about the balloon release. Well, he told you, ladies and gentlemen, that he wasn't really very much talking with the family at that particular time, so they probably didn't tell him about it. But they may have told Mary, and maybe Mary thought that's where they were going. Who knows? Who cares? What does that matter at all? Nothing. They just happened to be at the wrong place at the wrong time. And at the time, they were leaving. They were going away. They weren't any threat. They weren't anything. They were just driving away. He was about to drive Mary home. They couldn't find the shop. He'd given up. He tried to reach his cousin, Squeaky. He couldn't get him. And then Mr. Gonzalez wants to say over and over again about, oh, and what's in his hand? That picture in his hand. Look at that picture. First of all, there is no way you can say there was anything in his hand. All right? There's a reflection from something around his hand. And that is why we called Officer Barreto back and introduced the fact that he was wearing an Apple Watch that day. And if you look at the photos that the state introduced with Officer Barreto's body-worn camera, one of them actually catches a reflection from that Apple Watch as he's talking to them. There's nothing in his hand. What you're seeing in that brief, tiny moment is a flash from his Apple Watch reflecting off something. There's no firearm. There's no evidence whatsoever, not even the tiniest bit, that Willie Brown had a gun, that Willie Brown shot a gun, that anyone in Willie Brown's car had anything. There's no casings in that car. There's no casings on the scene that are not identified to Quandarious Hammond at that time when Willie Brown gets out, because Willie Brown gets out right there. And all of those casings were shot by the vehicle that he jumped out of trying to get away from. Not a single other casing from an unknown gun. There was no other gun. Why would Willie Brown be running the way he was running if he had a gun? There's no evidence of that, and Mr. Gonzalez is trying to get you to imagine this. Remember, it's not an imaginary doubt. There's no evidence. If there was, as Ms. Ismer had told you earlier, if there was even a scintilla of evidence that there's possible self-defense, you'd be getting a self-defense instruction. There's not. And remember, what Mr. Sampson was screaming out when he was standing up and all that, that's not evidence. You're not to consider it, and the judge already told you to disregard it. And I would ask you all, please follow that law. Look at the actions of Zvante Sampson, because now I'm going to kind of go through each one individually. Look what he did. And I've already said a number of it, but I'll say it again. Watch that video. Watch how he's paying attention to what's going on, to where James Denson went. Watch how he's paying attention to that. Watch how he gets together. Are they saying he was like willfully blind and didn't see any of the guns around him? There were guns all around him. You didn't see Andrew Thompson masking himself up with a shirt? Come on. You know, the one thing Mr. Fischetti said that I absolutely agree on is that you do not leave your common sense at the doorstep. You take it back there with you. Okay? They all knew what was going on. They all saw the guns. They all saw, Mr. Thompson masking himself. Everyone knew what time of day it was, okay? To suggest that Mr. Sampson was like, oh, I didn't know anyone had a gun. I didn't know what was going on. I was just going to go for a little quick ride. Come on. Use your common sense. That makes no sense. He went out with a targeted plan, and he has fellow people, and there are 2 cars behind him coming along with him. And he led the charge, and he took him right there. And you watch those brake lights come on just as he's approaching the victim's vehicle, giving Quandarious Hammond a chance to shoot. There has clearly been some discussion, and rightfully so, about the gun that was later found. Raheem Bryant had the gun. And you've heard that Detective Salea went and interviewed Raheem Bryant because this gun, which was found months later, I might add, in a whole separate case, who knows how that gun came to be there, who knows how, but Raheem Bryant was not identified in any of the videos from the Chevron. Not one. He was not out there that night. He was not there. He was not a participant. There's no way he could have been charged. Another thing that was a theme from a number of these defense attorneys behind me, and I'm not going to go through each one individually, but a lot of them kept saying, this is a circumstantial evidence case. This is a circumstantial evidence case. Ladies and gentlemen, this is not a circumstantial evidence case. You have direct evidence. Video is direct evidence. That is not circumstantial. What you see these people doing, getting in the cars the way they got in the car's driving, the casings and where they're found, all of that is direct evidence, not circumstantial evidence, as the defense keeps trying to say over and over and over again. You have the videos. You have the phone records. Sergeant Van Heist shows that almost all of them, other than Andrew Thompson's, all of their phones were right there, right at the scene when the shooting takes place, based on those advanced timing records on T-Mobile. Direct evidence. Direct evidence, the casings matching the gun in James Denson's hand. Direct evidence, not circumstantial evidence, direct evidence, which means he shot out of the car that was being driven by Jaylin Bedward. Direct evidence. We see Jaylin Bedward get in that car. He admitted, again, an admission from a defendant, direct evidence. He admitted he drove that car. He drove that car where we see these rifle shots come out and where we see the shots that James Denson fired that are connected to James Denson's gun. Direct evidence. This is not a circumstantial evidence case by any means. Please don't get confused. All of those things I've just mentioned are direct evidence. The fact that they lied, the fact that they all said, oh, we were going straight, we never made the U-turn, and we know that that's true. That's not true. They did make that U-turn. Again, direct evidence. All of this stuff is direct evidence, not circumstantial. Jaylin Bedward, holding the AR. If you watch the video, Jaylin Bedward he's the one who trips and falls. He's the one who was out there with the group on the field watching Willie Brown's car. He comes running back and again, in his excitement, trips over a thing and falls, gets up, takes his pistol, puts it back in the car, comes out with an AR. And you can see it. We tried to slow it down for you in the presentation, but not only do you see it, but he admits to Detective Celaya that, yes, that's my AR. When a search is done of his car, there's a box for an AR, no AR. Evidence. We see Jaylin Bedward get into the driver's seat. Again, with the AR that shot from his car. The AR that shot from the passenger seat, where we know the only person that was sitting there was Andrew Thompson, the one who was masked. So Jaylin Bedward not only drove them to do this, he also provided the gun. That's a principle, ladies and gentlemen. He was the third vehicle. He can't possibly say, I didn't know what was going on, because by this point, that car is shot up, it's crashed into a pole. And he still drives by so that his passengers, Andrew Thompson and James Denson, can continue to shoot up that car, continue to shoot at those occupants, make sure those people are dead. That is first-degree murder. That's attempted first-degree murder. Again, Bedward lied, said he never made the U-turn. Why did he lie? Because he didn't want to admit to Detective Celaya, yeah, I made that U-turn and I drove him right down there so we could shoot up that car, because he was guilty. And he knows it is, a guilty conscience. He couldn't tell them the whole truth. Yeah, I got in that car and drove, but I didn't make that U-turn. We know he made that U-turn. We see the muzzle flashes coming out of that passenger seat where Andrew Thompson is sitting. And then James Denson, Mr. Fischetti, gets up here and look at the conduct of the accused. Well, look at his conduct. He's one of the main instigators. He's the one who goes out there and is the one who's really checking out what that car is and who that car is, and he's the one who runs back and tells everyone, and he gets in that back seat, and he makes sure he fires off a couple of rounds himself. One of the things Mr. Fischetti, though, I think fails to think about when he talks to you about the location of those casings. Yes, they were west of the vehicle. But use your common sense. Think about how those shots are occurring. He is driving by in a vehicle going very fast, and he's firing out the window. The momentum of that car is going to carry those casings along with the direction of the travel of the vehicle. So yes, those casings are west of the vehicle, and you can see that in the shot, or in the diagram that shows where all the bullets are. But of course it is. Where would you think it'd be if he's firing as he's passing into a car that's just crashed, and the bullet gets ejected, or the casing gets ejected, and as it's ejected, it's going at the same speed as the car. So if that car's going 40 or 50 miles an hour down Hillsborough, that casing's traveling 40 or 50 miles an hour in a westward direction as well. So when it hits the ground, it's also flying that way, because it was with the car, and it's thrown out. If you throw something out of a car, it's going to continue that same momentum in the same direction as it's going when it's going with the car. That's why the casings are slightly after. It wasn't like he just had an afterthought and thought, oh, I'm just going to shoot it backwards or shoot in the air. He was shooting at that car as well, just like they all were. And we know he was shooting because we have his gun. And he told those detectives, no one ever takes my gun, that's my baby. I always have it on me. It's mine. And we see him get in that back seat of that car. Again, one of the things Mr. Fischetti said, and a lot of them were saying, was that we keep saying they, we keep saying them. Yes, we do, ladies and gentlemen, because they work together. That is the whole point of a conspiracy. That's the whole point of charging people as principals. To say they are working in concert, they are working together to achieve a common goal or purpose. In this particular case, their common goal or purpose was to shoot up and kill whoever was in those vehicles, or in that vehicle. That was their common goal or purpose. So yes, I am going to continue to refer to them as they in these actions, because their actions should be construed together. We were never going to tell you, and never plan to tell you, exactly who shot the fatal shot, because we don't know and we will never know. And that's not something we have to prove. As long as we can prove to you, beyond a reasonable doubt, that these men all work together to achieve that purpose. That is murder in the first degree as a principle. Had Quandarious Hammond not shot up that car at the initial thing, they wouldn't have been stopped there, as long as they were, to give cars number 2 and 3 a chance to come up and catch up with them and shoot them. Again, it's a team effort. I talked to you about this in Bordire. When Baker Mayfield throws a pass to Mike Evans for a touchdown, The points don't go to Mike Evans, they don't go to Baker Mayfield, they go to the team as a whole because they were all working together to achieve that purpose. You have the blockers, you have the running backs who take the fake handoff. You have all of them working together for the same purpose. Just like here, these men were all working together to achieve the same goal. And we know that because of what? Their actions. Look at their actions. Mr. Fischetti talked about an act, that you got to prove my client did an act. Remember, the definition of an act is an act includes a series of related actions arising from and performed to a single design or purpose. I can't think of anything more than James Denson shooting at that car as part of an act, part of a single design or purpose. They're all in the same single design or purpose. Clearly, James Denson knew what he was doing. Remember, he got in the car where Andrew Thompson is masked, okay? Let's not forget that, because that is a very strong piece of evidence, direct evidence I might add, not circumstantial, as to what was in the minds of these individuals. Why are you going to mask yourself? What is the purpose of that? Think about that, ladies and gentlemen. You know what the purpose of that is. Doesn't want it to be identified. Mr. Fischetti wanted to talk about his admitting that he pawned it. Clearly, he had no consciousness of guilt. Look, just because a person is not smart doesn't mean that they're not guilty, okay? Just because James Denson might not have thought of the fact that a couple of his casings are going to be matched to that gun doesn't mean he's not guilty. It's just as likely that James Denson thought he had gotten away with it and didn't realize or didn't think or didn't know that a casing can be tied back to a particular gun. Mr. Fischetti talked about a reaction when I was talking about the red light. This is not a reaction, this is an action. He's not reacting to anything. He is acting. He is taking the positive step of taking that gun out and shooting it. That is an action, not a reaction. Please don't get confused on that. He made that choice. He made that choice when he got in that car. He made that choice when he brought along his gun. He made that choice when he pointed his gun out the window, and he made that choice when he fired that gun 2 times at the car. An active choice. An action, not a reaction. With Mr. Thompson, Mr. Sonardi got up and talked a lot about this being a circumstantial case, and I believe I've already talked about this. This is not a circumstantial case by any stretch of the imagination. This is a direct evidence case. You have been given a plethora of direct evidence in this case. Is there some circumstantial evidence? I guess you could potentially say that whether or not there was a conspiracy, maybe some circumstantial, but we have direct evidence in that too, because we have the video from the pawn shop that shows their actions out there beforehand. And if that doesn't show a conspiracy, I don't know what does. These men were clearly acting together. They were clearly communicating with each other, and they clearly went and did an action with the same design or purpose. All of them. There's been a lot of talk about the people not charged in Car 2. I hope, ladies and gentlemen, none of you are going to go, well, I believe they did it beyond a reasonable doubt, and I believe they were part of this conspiracy, and I believe they shot at that car intending to kill those people, and I believe all that. But you know what? They did catch the other guy, so maybe I'm not going to find them guilty because of that. Please. I beg of you, don't do anything like that, okay? Just because some other individuals may have gotten away with this does not mean that these 5 should as well. There's a big difference between potentially identifying someone and proving it beyond a reasonable doubt. A detective's belief that someone is a certain person is not sufficient. You need more than that. In this particular case, we have admissions from all 5 of them that they are, in fact, that individual that's in those cars. You didn't hear anything that there was ever anyone else who admitted to being in that car, too. We don't even know for sure the driver of that car, because if you watch that video on the Chevron, car 2 pulls up, the driver never gets out. We don't ever see that driver. They're assuming it's Maxwell Bedward because Maxwell Bedward was driving that car earlier in the day, but at that particular time, they don't know. How can I bring a case? How can the state bring a case to prove beyond a reasonable doubt when we don't even know for sure the driver of that vehicle? We also know that a number of people got in that car, but we can't say for sure which one of those shot. In each one of these cases, we can say that each of these passengers shot. We know that. We know it's Quandarious Hammond because we know it wasn't the driver shooting, it was a passenger shooting. There was only one passenger, and that was Quandarious Hammond. Very simple. Easy. Proof beyond a reasonable doubt. In the third vehicle, we know Jaylin Bedward was driving. We know the front seat passenger was Mr. Thompson. And we know James Denson was in the backseat. We have 2 casings that are connected to James Denson, so we know he fired from that backseat. And we know there was this person shooting from the passenger seat because we see all the muzzle flashes. And they are big muzzle flashes, ladies and gentlemen, which I suggest to you is the AR. And that's where all the rifle casings are too, right where those muzzle flashes are. Because Andrew Thompson was shooting that gun in that passenger seat. He was firing that AR that he got from Jaylin Bedward. Also not circumstantial for Mr. Thompson is he's the one who's masking himself. And we see that on video. Another thing Mr. Sonardi brought up was the AT&T phone records. And I submit to you, yes, at 9:09 and 55 seconds, which is about 5 minutes after the shooting, it does appear that his phone is slightly away from the location. Now, again, you heard from Sergeant Van Heist that AT&T is not, their records are not as precise as T-Mobile's. T-Mobile can give you that time in advance where you can know almost to a very general location. That AT&T is more of a, they just give you kind of a circle somewhere. But again, this was 5 minutes after. At the time of the shooting, unlike with all the others, we don't know where his phone was because it's not pinging or hitting off any sort of a tower. At that point in time, 5 minutes after the shooting, Mr. Bedward very well may have been driving him somewhere. But again, the timing of when that comes in is pretty important because it is well after the shooting. We don't know, based on the AT&T records, where his phone was at the time of the shooting. And we also can't say whether that's even accurate because you heard that AT&T is not as accurate as, or precise as T-Mobile. But either way, there's no doubt whatsoever, that he is the individual who's masked and who gets into the passenger side of that Chrysler 300, which does not stop. You'll hear it, you hear it in that power election driving at a very fast rate of speed. There was no way for anyone to get out of that car. And we know only 3 people get in that car. We know one's driving. We know one is sitting in the passenger seat because we see the muzzle flashes from an AR coming out of that passenger seat. And we know that James Denson was in the back seat shooting that car. So Andrew Thompson's in that car, regardless of what the phone may say that where he was 5 minutes later. We also showed you pictures from that side view mirror where you see there were some scratches on the top of that mirror. Very easily could have been done from a rifle that's sitting out, that's firing and scratching along the top of it. Very consistent. And then Mr. Hammond. What do we know about Mr. Hammond? Well, we know that Mr. Hammond is the one who got in that car, got in the first car, in the car driven by Zvante Sampson in the passenger seat. We know he had a gun. We've seen the gun. We know that the first car is the first car that stops at Lorenzo's, or that catches up with him at Lorenzo's garage and shoots at that car. And we know that, again, because this is very important, and Ms. Isper pointed this out in her initial closing, and I think you all need to really make sure you remember this. The second and third car haven't even passed Power Electric. They're still way back there when the shots ring out. The only car that is there is Zvante Sampson's car. And the only person in Zvante Sampson's car that could be shooting from the passenger seat is Quandarious Hammond. So we know that he was the first shooter, and those are his casings. We know that Hammond lied about getting dropped off and getting picked up by his girlfriend. We hear the phone, where he's on the phone telling his girlfriend, she's like, oh, I already told him I was in St. Pete. I didn't say that. We know that he did a phone search where he was looking for video footage of 4-year-old girl shot in Tampa. That was on his phone, ladies and gentlemen. That was a search. He wants to know what evidence the state had got. He wanted to see whatever video footage there was. Consciousness of guilt. Speaking of consciousness of guilt, don't forget Jaylin Bedward, who Mr. Hernandez wanted to tell you was so cooperative. When they finally got his phone, it was completely wiped clean, factory reset. So we don't know what Jaylin Bedward might have looked up or what he had on his phone. Again, Ms. Bradley spent a lot of time on car 2. Knowing who might possibly be in the car is very different than proving it beyond a reasonable doubt. Knowing who fired what weapon in that car is almost impossible. But again, I urge you not to be like, well, they couldn't get all of them, so I'm not going to find any of them guilty. If the state has proven to you beyond a reasonable doubt that these men did what we have alleged they've done, they are guilty, regardless of whether or not there are other people who were helping them, or other people who were involved in it, or other people who were working along with it. It does not matter. What about the other people is not a defense? Look at their actions.
I'm sorry, I couldn't hear you.
Objection, denigrating the defense in the top argument.
Ladies and gentlemen, this was a hunt, an ambush, directed by these men to take out and kill the passengers of a silver Infinity being driven by Willie. Pure and simple ambush. They worked as a team. It was coordinated. One went by and shot, another one went by and shot, another one went by and shot. They were going to make sure that they got these people, whoever they were. It didn't matter to them. They were all going to die in that car. That was their goal. That was their intent. That was their plan. That was what they tried to do. And sadly and tragically, they did do it for one individual, 4-year-old Suni Bell, who happened to be in that back seat, ladies and gentlemen. They worked together, and they are all guilty, as charged, of all of the crimes for which the state has charged them with. And we urge you to return a verdict of guilty as charged on each one of them, on each charge to the highest level proven, which is first-degree murder, attempted first-degree murder, 2 counts, conspiracy to commit first-degree murder, shooting at within or into a vehicle, and discharge of a firearm from a vehicle. Thank you, ladies and gentlemen.
All right, ladies and gentlemen, we're going to recess for the day, and I'd ask that you come back tomorrow at 8:30 in the morning, where I will read you your final instructions, and then you will be able to begin your deliberations. Thank you very much. We'll see you tomorrow morning.
All rise for the jurors.